Good afternoon, everyone. Welcome to the Appellate Division, First Department. This afternoon, we have over 6 hours of argument time, so I ask you to please bear that in mind as I call the calendar. Remember that we have the briefs, we have the record, we are fully familiar with the facts of your case, and you should focus on only the issues, your most important issues, to make the points that you wish. Okay, People versus Ryan Cruzado. Submitted. Martinez versus the City of New York. Time? The amount of, if you would rise, please, and tell me the amount of time you would like for your argument. You said you're the appellant, are you not?
We requested 15 minutes.
And what? Okay, so I've asked that you, okay. Yes? Well, you can choose to, or I will if I see fit, but I was giving you the option.
I'll leave it to you, Your Honor. I just want to reserve some time for the vote.
Okay. Okay. I'll do 6 and 1 and 6 and 1 for now. Okay. Olga R. versus Olga M. Submitted. Real World versus 393 West Broadway. Is the respondent here? 6 and 1 and 6 and 1. I'm sorry, there's no cross appeal here. 6, 1, and 6. Tahari versus Narcos. Is there a cross appeal? I don't see one. So if there is no cross appeal, you do not get an additional number of minutes, okay? So that would be 5 and 2 and 5. People versus Ruddy Osias? Or Rudy? 5 and 2? 5, 2, and 5. Thank you. Patel versus Maybank Kim Eng Securities. 4, 2, and 3. Thank you. Gamma USA versus Pavarini McGovern LLC. 5, 2, and 5. Thank you. People versus James Rockever.
For appellant, 5 and 2, please.
5, 2, and 5. Thank you. McCann versus Shipwrecked Bar. 5, 1, and 3. Thank you. Island Consolidated versus Grassi and Company. 6, 2, and 6. People versus Brandon Vieira. Submitted. HG versus NYC Transit Authority. 6, 2, and 6, thank you. Pineda versus Santana.
Good afternoon, Your Honor. Aaron Fuldenauer for Appellate 6 and 2.
5, 1, and 4. And Pineda versus Reyes.
Good afternoon again, Your Honor. Appellants 6 and 2.
5 and 2 and 5. Thank you. I will call the last two cases, which are election cases, first. So we'll start with Pineda versus Santana.
Good afternoon, and may it please the court. Aaron Fuldenauer for appellants Alexander Lorenzo Reyes Pineda and Tomas Ramos. This case presents three key legal issues for the court's review. The first is where petitioners submit a petition to invalidate and incorporate by reference their specifications of objections in their petition. Is fraud adequately pled? Petitioners, appellants respectfully request that the answer is yes. Here, it is undisputed that 10 deceased individuals.
Counsel, how was that adequately pled?
It's adequately pled.
What words were you used in the pleading?
In the pleading, the words were used that that fraud, that signatures may have been forged.
So, in
or
order
other
for
fraud in the complaint.
for fraud to be adequately pled, it has to be done so in a particularized way, not just a generalized assertion of fraud. What within the record and within the paperwork suggests that that allegation was particularized?
Right. So widespread appellate division authority holds that the specifications of objections can be incorporated into the petition by reference. And here, before the petition was filed, the specifications or objections.
Counsel, I don't know what widespread cases you're referring to, but in election cases, the petition itself is not satisfied unless there's a particularity in it, as my colleague has referenced. And it is not satisfied merely by reference to the Bill of Particulars. The pleadings themselves have to have the specificity required.
Well, actually, the cases I'm referring to are Oberle, Matter of Maza, Cohen v. Moss, and Matter
Those
of
cases
Haygood.
can be distinguished from this case. So tell me how in the pleadings here you have specified the fraud that you allege took place.
Right. So in the pleadings, we specifically said that signatures, I don't have the exact language, may have been forged or fraud existed.
Well, I think what you did was, I think that there is is this the one where there's an F in the line? You have line by line, and you refer to the signature challenges on each line with an F. Is that right?
That's actually the next case, the Nicholas Reyes case. This
Okay.
case, we actually denoted death, literally the word dead or death.
But that does not raise an issue regarding fraud being particularized, right? Because there's so many different reasons as to why a signature could be on a petition of someone who's deceased.
It could. There's 10 particular particularized specific signatures that were identified as deceased. It's about as specific as you can get. And then beyond that, the court gave us permission.
Also, in referencing that they were deceased or dead, was there any further information as to pre-deceasing this signature? Like, you understand what I'm asking? Because dead, did they die yesterday, the day before? Is there anything in that?
Any language to suggest that fraud was involved in having those deceased signatures placed on the petitions?
Well, of course, being a deceased voter, it is fraudulent. And in our bill of particulars, which was
But
done
counsel,
pursuant-
you're not distinguishing whether or not it was the person who actually signed the line or whether it was the person who was holding the petition or anything in between. I mean, you would have to completely guess to understand what the basis of this petition actually meant, what the claim was actually for. And forgive me, but I still, perhaps I've put, but I believe that you did indicate with some, how did you indicate for each line? How did you indicate? What did you use to indicate?
For each line, the word death or dead or deceased was specifically noted. And this was filed in the record below, submitted to the board, and
So
served.
then, back to the question,
Yeah.
and the question I asked, it doesn't distinguish whether it was someone who signed it, whether it was the person who was holding the petition. There's no indication as to what evidence there is that these were the factors.
Well, actually, if I may correct the record on that, it's for the signer, the voter who signed it. On those particular lines, we identified 10 discrete voters on certain pages, certain lines, who were deceased. And the record does show that they were deceased long before the petition was signed.
Thank you.
Thank you.
May it please the court, I'm Martin Connor, and I represent the responding candidate, Raymond Santana.
Mr. Khan, I believe that the argument is that those petitions that were carried by the individual, where these 10 deceased individuals' names appear, that all of those sheets should be somehow invalidated.
Well, no, what my argument is that the 10, and I don't know that there were 10. This appeared in the bill of particulars, which was stricken, but I did the whole
My
line by
question to
line,
you is,
and there were a couple
Sir,
that said
my
dead.
question to you is, should all of the petitions that were carried by this individual, on whose petition those 10 names appeared, if it were 10 or more, should all of those petitions be thrown out?
Not on the proof that was adduced and the pleadings in the proceeding. There are cases, of course, where you do that, but you get testimony, you put some context on it. This is just a list. And I noticed a couple when we went through the line by line that the board had stricken. I didn't keep count of that. We didn't have a validate, so we didn't have to look at anything the board already tossed out. But there was no indication that there was no indication in the actual petition, other than that some signatures are forged or maybe fraud, and there was no reference in the petition whatsoever to any dead people.
Didn't the petitioners have an obligation under the 2025 election part rules for the city to present something more than what they did, a complete written offer of proof?
But besides the pleading, under the part rules, it says if you're going to raise an issue of fraud, you have to produce not a bill of particulars, you produce an offer of proof with detailed who are your witnesses, what are the lines, are they a handwriting expert, or are they
You have to detail the
a
fraud
signer?
allegation.
They didn't do that.
And with regard to the bill of particulars, were they in a position to even file a bill of particulars, given that they're not an aggrieved party?
Well, the part rules specifically say an aggrieved candidate must file a bill of particulars. It doesn't authorize anyone else. We didn't request it under the CPLR and under the rules for special proceedings. It's not a pleading that's listed there without leave of court, and he didn't get leave of court.
So,
for
which
that.
means that you're left with the petition, not with any reference to a bill of particulars.
Right. He didn't have a right to file a bill of particulars, and he had an obligation to file an offer of proof, which he didn't. And as to his other issues, which he didn't get into, but they're in his brief, this complaint about the cover sheet, I mean, the record clearly shows, the video shows, he asked to have the cover sheet. Never mentions that in his brief. He asked to have the cover sheet thrown out. They did it. When he protested, one of the commissioners said, that's what you asked for. The fact that he doesn't like what the result was, that's his problem. I mean, think before you ask for something. But any other questions? I think the record's clear.
Thank you.
A few corrections for the court. First of all, an offer of proof was filed. What counsel is arguing is that
When was the offer of proof filed?
it was filed pursuant to the deadline on April 22nd. It was substantial detail.
What did it say?
It itemized all of the individuals, the 10 deceased individuals who purportedly signed, when they died, and the fact that they died long ago before they signed the petition. It also said
Well,
that
that
these were-
sounds like a challenge to the signatures on the petition. What we're asking about is an actual offer of proof as per the part rules that detail what the actual fraud was.
Right. The offer of proof, it's NICEF numbers 13 through 25. Again, it's titled Bill of Particulars, but all of the information
Right, but
in
so
offer
if
of proofs,
it-
it's a word
if-
game over the title of the
But
document.
you're not as the party, you're not entitled per the part rules to file a bill of particulars. Are you an aggrieved candidate?
No, but in fact, we were. The penultimate paragraph of the
But counsel, may I just stop you? You just are saying that this is entitled, it's titled a bill of particulars, but you weren't entitled to file a bill of particulars. The part rules indicated that. So if you misstated or mischaracterized whatever it was, the court looked at that as a bill of particulars, and it wasn't supposed to be, it didn't consider it. I mean, it's not to be, you didn't have the authority to file such a thing at the time.
No, I see my light is on, but it's the penultimate paragraph of page 1. Specification of objections not previously filed and served with the board should be uploaded by Tuesday the 22nd at 10 a.m.
But
Then
then
the
in the
next page-
next paragraph, it references the specific aggrieved parties part, right?
Which is a separate thing. And remember, an aggrieved candidate can also serve as an objector as well.
But
So
there wasn't an aggrieved candidate in this case.
it wasn't an aggrieved candidate, but that's why the penultimate paragraph does govern here, which doesn't specify aggrieved candidate. Anyone, and in fact, the case law, which is all cited in part 2 of my brief, goes through in detail why any party is allowed to submit additional objections. This is not an administrative review of the board. It's a de novo proceeding. And if I may correct one factual record on the last part of the brief, I never asked the Board of Elections to do what it did. What I asked the Board of Elections to do was either throw out the entire petition or go back to the 3 volumes only and rule only on those 3 volumes. And I cited a lot of case law, including the Pataki case from 1976, which talk about how the board can't act at this late date to change the petitions that were in the signatures. So thank you very much for
Thank
hearing
you.
me on this issue.
Thank you.
Yep.
You're back up on Pineda versus Reyes.
Good afternoon again, and may it please the court. Aaron Foldenauer for the appellants. And if I may, this case presents 2 key legal issues for the court's decision consideration. And the first one is, again, the incorporation by reference issue. And my friend, Respondent's Counsel own cases show that specifications of objections can be incorporated by reference and are sufficient to plead fraud. In fact, it's the It's the Waugh v. Nowicki case that Respondents' Counsel cited. It acknowledged that if specifications filed and served with the board are sufficiently detailed, you can incorporate by reference, and that's sufficient to plead fraud.
But the key component of what you said is sufficiently detailed. Were the specifications here sufficiently detailed?
I think they were. They specifically identify forgeries with the Code F. So this is the one that does identify with the Code F those specific forgeries at issue.
So
And
does specifying a forgery rise to the level of particularly pleading fraud?
yes, a forgery is one type of fraud, and then of course they had notice of that, and then we filed our bill of particulars. Again, the term bill of particulars / offer of proof. Again, this was NICIF numbers 7 through 10.
Did you ever argue below that the bill of particulars was not in fact the bill of particulars, but actually an offer of proof to the court?
This issue was never really argued in any detail before the court. But again, we were required, the offer of proof.
I would imagine that the issue would come up when you're discussing with the judge whether in fact you've particularly pleaded fraud. If you're indicating that those specific allegations are contained in your bill of particular or / offer of proof, that's when the argument would come up before the judge, right?
It should have come up in more detail. There was very little discussed about this, but I note that.
I'd like to ask you another question.
Yep.
So with regard to this F, just with regard to this specificity, did you simply say F? Did you say forged signatures? Did you say signatures forged and that do not match the signer's voter's registration?
Well, the code indicates.
Right, and the code could either
entirety of
be
that.
forged signatures or those that don't match the signer's voter registration, right?
That sounds about
So-
right, Your Honor.
So again, if you look at the requirements of fraud, there has to be some material misrepresentation, and it has to be, clear that that's what's considered. I mean, here, the not matching could be a number of different things. The person might have changed the signature. The person might be elderly, and your opposing counsel lists all the variations on that. So from a perspective of specificity, do you satisfy that by simply indicating the way you did without anything further?
Yeah, I would submit that identifying a forgery is in fact a very specific allegation. They're on notice, and this is well before.
No, I'm saying you identify it with an F, and an F refers to two different potentials, right? Possibilities. Isn't that correct?
It
The
could.
F refers to the signer's vote doesn't match, or it refers to a forgery.
Right, and we also use the code SH in some instances, similar handwriting, because there was similar handwriting here, which is also indicia of a forgery. And so I do think it's pled with particularity under the Appellate Division Authority I've talked about, including Waugh v. Nowicki that Respondents' Counsel cited. And with respect to the additional objections, which is also the issue, the additional objections that were submitted, and again, it's the penultimate paragraph of page 1 of the rules, his own cases also show that. The Lancaster case, it talks about how the Supreme Court may entertain additional specific objections as long as respondent was giving adequate notice. He cited that case. The Mataris-Stavisky case that a Respondents' Counsel cited said, quote, a court is obligated to consider each objection to the designating petition properly placed before the court, and it was. And the Balak v. Rossi case also says that a court has jurisdiction to hear objections to specific signatures other than those that were objected to at the Board of Elections. And no one has even talked about yet the very language in the court's own order to show cause here, which specifically authorized petitioners to show up in court and to bring additional objections and additional objections of fraud, which petitioners did.
Thank you.
Good afternoon, Your Honors. May it please the court, Paul D. Newell for Respondent Nicholas Reyes.
Counsel, just in terms of using the code F to denote a forgery, why isn't that enough when, as detailed, the definition of forgery encompasses two separate things in terms of this election law case? Why isn't it just enough to just say forgery, F, this is the problem with the signature? Why isn't that particular enough?
Because the F, as appellants argued it at the court below, does not represent fraud. It represents forgery or signature does not match the buff card. And that is what they argued for 199 lines before the referee. Also, even in the, and as discussed, a signature not matching cannot match for any number of reasons. A forgery, even if there is a finding of forgery, and there were none here, and it's a very difficult threshold, who is to say that forgery is by the subscribing witness and therefore going against a petition and towards permeation as opposed to by a voter or the person on the street? Plenty of people will sign a fake name on a petition, sometimes women for privacy or safety concerns, sometimes opposing candidates intentionally send someone to sabotage.
So
Sometimes
the
people
forgery
are having a
might
joke.
not necessarily be a fraud. It could be something else.
Exactly.
So do you need more particularity?
We need more particularity. Counsel has cited no authority for the fact that the bare inclusion of an F meets the particularity requirement. He spends a lot of time saying that he's permitted to incorporate the specifications of objections, and indeed he was and did incorporate the specifications of objections. We do not dispute that. We dispute that those specifications of objections detailed fraud. And it is entirely possible to do so in specifications of objections. You can have it detailed on the line by line, or you can have additional pages at the front, usually done at the front of the petitions of the specifications of objections, detailing general allegations of fraud and specifying, oh, this person's dead, this what have you, this candidate did this. In this case, in fact, counsel's specification of objections did have an additional sort of general page about something about the candidate's apartment, which was not addressed in the case and is not significant. But clearly, had they been pleading fraud, could have included it there, or they could have included it in the petition itself, but they did not do so. And they've cited no case law saying that an F is sufficient for particularity, nor do they cite any case law whatsoever that a citizen objector whose entire standing is based on the fact that they find an administrative proceeding arbitrary and capricious have injury to bring another set of objections. It is not possible that the Board of Elections was arbitrary or capricious in not sustaining objections that were not submitted to it.
Still have 2 minutes.
So, that is the bulk of the thing. He is not. None of the cases he cites give him that authority. There was no offer of proof provided at all, which was clearly required to plead fraud. So he's out of compliance with the part rules. Counsel says this issue
He
was
said
not.
that his bill of particulars was inartfully named bill of particulars when in fact there was an offer of proof. Did that issue come up?
It did not. Counsel at no point requested the court to reform or recast the bill of particulars as an offer of proof, nor does, in fact, the bill of particulars meet the requirements of an offer of proof under the CPLR. Counsel says this issue was not discussed. It was, in fact, briefed. It was not discussed so much orally, but it was briefed at the court below, and those are all on the record. And it is clear that there is no standing to bring a bill of particulars. There is no specific allegations of fraud whatsoever, never mind meeting the threshold under 3016B to plead fraud or to have fraud properly before the court. And counsel cited no authority to the contrary.
Thank you.
Thank you.
So had the letter F been cast as fraud, I'm sure respondents' counsel would have argued that, oh, you just argued
But
general
that's not the case.
fraud.
What he's arguing is something else, so.
Right. But so a forgery is a very specific type of fraud. I hope everyone here can agree that if a signature is forged, that would constitute fraud.
Except that what the definition here or what's allowed is broader than that. So it's not possible to determine that from just the F.
Well, the F clearly indicates fraud. The F, of course,
It's possibly fraud. Possibly fraud.
Well, but if we had put in the petition upon information and belief, these certain signatures were forged, that would mean the same thing. So, but it's just coded.
Well, certainty does mean certainty. Certainty doesn't mean it's the possibility that it's this, or it's the possibility that the person is older now and the signature looks different, or there's a possibility of some other reason other than fraud or a forgery.
Well, again, it's the same thing. You could say the same thing if it were written out in a complaint. Of course, in an answer to a complaint, someone could say, well, that person's handwriting changed or whatever. But the fact is, the
Counsel, I
forgery
think
was
the
alleged. Whether
point is, in fraud, in an allegation of this, which forgery would be, it has to be specific. And for each line, it wasn't specific because the F could relate to other things other than a forgery. So that wouldn't meet the specificity requirement, would it?
Well, no, because again, if you had put that in put it in the complaint, same thing. You could say the signatures were forged or did not match. Then I think, then again, I think that would qualify. It's just a matter of whether it's in the pleading or in the specification of objections. And here it's incorporated by reference. And again, it would again refer to the Bill of Particulars, NYSIF 7 onwards, which contains multiple pages of information concerning the fraud, the signatures at issue. It was uploaded pursuant to the court rules. And again, it's an issue of the title, as Justice pointed out a few minutes ago.
Thank you
It
very
was
much.
submitted. Thank you.
Thank you both. Martinez versus the City of New York.
Good afternoon. May it please the court. My name is Jerry Goldfeder. I represent the appellants here. The case before you is an election-related case, although it's not a ballot access case like the ones that you have just been hearing. Here we have a law promulgated by the City of New York. Now, the City of New York, like every other locality, is entitled to pass its own ordinances on a variety of subjects pursuant to the New York State Constitution. However, it's circumscribed by the fact that it can't pass laws that are not constitutional, either under the federal constitution or the state constitution. It can't pass laws where there's a preemption issue. And I would suggest to you that, in fact, this local law does violate the United States Constitution and the state constitution. And, in fact, there is a preemption problem. If you decline to adopt that the law is
Counsel, why don't we
unconstitutional,
discuss-
is preempted, then alternatively, if in fact it's a valid exercise of a law, it's not operative because it should have been
Counsel,
enacted by referendum.
why don't you tell us how this local law preempts or violates the rule with regard to the state law, where it does not narrow the state law at all. It lists things that are different, of course, but it doesn't narrow it at all. How does it?
It doesn't
where's
have
the
to
conflict?
narrow the law. Preemption, it doesn't preempt state law.
It doesn't preempt
It's
it.
preempted by state law because it's inconsistent with the state law. The
But
state
it doesn't,
law-
it doesn't take something away from the state law. For example, it has, I mean, it is possible, and I know you raised the argument, that one can run for election under the state law, but not under the local law.
Well,
But
that's
it's
what-
not eliminating some factor that the state law has required.
Well, it does because the state law says this relates to all civil offices. Council says that in order for preemption to occur, the state law needs to affirmatively, explicitly refer to, in this case, the city council. It doesn't. It says all civil offices in the state, and these are the offenses that are covered.
So, Counsel,
Once
then
this-
it's your position that just with that interpretation that a local city government could never implement their own set of criteria for people running for office?
Well, it can if it's not preempted. In this case,
But if you're saying that it says all civil positions, then when would they be able to do that?
if it doesn't have anything to do with disqualifying a candidate for committing a crime and being convicted of a crime.
And when
That's
could
what
that
this
happen?
law-
When could that happen underneath your interpretation?
I'm sorry?
When could that happen underneath your interpretation, the way that you want us to interpret the preemption issue, the way you want us to decide it? When could the local government ever control their own local elections in that regards, in terms of criteria?
A municipality cannot enact a law disqualifying a candidate who's committed a particular crime because the state has enacted a law that says this covers all civil offices, and these are the specific crimes that disqualify someone.
Counsel,
If
so
in
under
fact-
your analysis, the local entity could never enact a local law that regulates who can run for office based upon having committed a crime.
That's correct, because the state has occupied the field here. And this particular, when you look at the laws, the common law relating to preemption, the preemption issue, if a local law is inconsistent with the state law, then it's not
So
valid.
this is even though the local law says in addition to any disqualifications for holding civil office that's contained in the state law. So they can't do that.
That's right. Just because they added the words in addition doesn't absolve them
to
of the
be-
fact that they don't have the authority to do so.
But
So
to do,
here what-
to actually have field preemption, doesn't the local law have to clearly evince some sort of desire? In other words, saying, we don't want, X, Y, Z that's in the state, that the state law has articulated. Don't they have to?
They don't have to say it that way.
Don't they have to clearly evince some desire to preempt an entire field that precludes?
The state law, the state law does not have to say, we are the authority from A to Z. By virtue
It has
of the
to
fact that
it has to in some way indicate an intention to be the final word on the particular topic.
It doesn't have to do so explicitly. It could be explicit or implied in the law. And when the state law says, these are the items these are the crimes, I should say, that disqualify a candidate for civil office under these conditions.
Would that particular public officials law have to then further say, and no, these three and no other?
They don't have to say that. They don't have to.
Wouldn't that be
explicitly
expressed?
say-
Wouldn't that evince their intent to occupy that area? That
They don't have
field?
to say that explicitly. In fact, the case that counsel has indicated, the PBA case, says in its decision that a state law doesn't have to expressly say what you've just suggested. We are occupying the field. It doesn't have to say that.
But the
We
state
don't want
counsel,
any other crimes.
does the
It
state-
doesn't have to say that.
Does the state law have to expressly prohibit something that the local law has permitted?
It doesn't have to expressly do that.
But in this particular case, with the kind of issue that it is, with felonies, there are tons of felonies. It
That's
could
right.
be that they thought of some. They don't say the whole category of felonies.
That's the point.
If I can,
sorry.
they state a couple of felonies. And what I'm saying is, doesn't the state have to make clear that they intend that whole category, which I think has been asked already, that the whole category of felonies is excluded? Maybe they didn't think of.
They don't have
May
to
I just finish? Maybe they didn't think of the other ones. So now the local law says, you know what, these particular felonies, we don't want someone to hold these important offices with these particular felonies that the state has not yet commented on. How is that preempting this?
how do
How is
we
that
figure that out?
stepping on the state?
So how do we figure that out? There have been multiple attempts by various legislators of proposed bills put in the hopper that indicate that state law should be expanded by including the crimes that are in Local Law 15. They have not been passed. We can infer from that that the legislature doesn't want to include them.
But for
The
field,
state-
but for field preemption, which is what you are arguing here, right? Wouldn't it have to, I'm just reading from the Chewett case, express statement in state statute explicitly avers that it preempts all local laws on the same subject matter. We don't have that here. Declaration of state policy evinces intent of legislature to preempt local laws on the same subject matter. We don't have that. And the legislature's enactment of comprehensive and detailed regulatory scheme in area of controversy is deemed to demonstrate its intent to preempt local laws. We don't have that. So what
I'm sorry, what are you reading from?
the Chewett case, I don't know if I'm pronouncing that correctly.
I'm sorry, but I didn't hear the last thing you said. I apologize.
I don't know if I'm pronouncing that correctly.
Oh, okay, fair enough. It doesn't have to be explicit. They can occupy, the state legislature can explicitly
Preemption has to be expressed, though, right? It can't
be
just,
implied. It could be implied by the fact that,
but it has to be implied in the ways in which my colleague just listed to you from case law.
okay, so if in fact that's your view, let me suggest the following, which is a local law can't be inconsistent with the state law. If it is, that's also a cause for preemption and invalidates the law.
This law, how is this law inconsistent with the state law?
This law is inconsistent because it has a provision, and there's no severability. It has a provision for a pardon. If a person who is convicted of one of the indicated crimes is pardoned by the governor or the president of the United States, the law is no longer in effect. They can run for office and serve. The state law doesn't have that loophole. And in that regard, the local law is inconsistent because it says, the local law says, if you commit these certain crimes.
And when we say certain crimes, let's just be clear about what we're talking about, right?
I'm sorry?
When we say certain crimes, let's be clear about what we're talking about. We're talking about crimes wherein the public trust has been violated.
Well, yes, but what we need to keep in mind is whatever the substance is. Here we're talking, of course, about felonies. That's what the subject matter is. But when we're dealing with the issue of preemption, it doesn't matter what the laws are if it's inconsistent, and it is inconsistent because there's a pardon loophole which obviates the law.
Is it inconsistent, or does it give another option under the local law that doesn't exist under state law?
It doesn't have that. It doesn't have that authority to do so when the state law says this covers all civil offices. It doesn't have that option. That's the problem with enacting a law like this. Look, this is not a sympathetic character because we're talking about a felon. And intuition might tell us that, well, on some level, this makes sense. But in fact, it's unconstitutional because there's really no rationale that's been expressed by the originators of this bill.
Thank
that
you.
Passes.
You have some time on rebuttal.
Okay, thank you.
Good afternoon, Your Honors. May it please the court. Amy McCampbell on behalf of the respondent appellant, City of New York. Your Honors, I'll start with preemption since that was my adversary's focus. So here, as Your Honors pointed out, to show field preemption, the legislature has to clearly evince an intent to preempt the field. Simply
What about
passing
what
a law.
counsel said?
I'm sorry.
Not hearing me. I said, but what about what counsel has argued, that with regard to field preemption, the state has spoken. Once the state has spoken, we can't there can't be anything else. You can't have another felony.
There has to be something that shows an intent to preempt the field. It's not enough for the state to just legislate on a particular topic. It has to clearly evince an implied intent to preempt the field. And I point this court to the PBA case from the Court of Appeals, 2003, and also the Garcia case.
So, I mean, the state law does says no person shall be capable of holding a civil office who does this. So how can the city then say, well, we think that no person should be capable of holding a city office if we do this? And I mean, it's certainly not, the state law is certainly not going to say, we hereby preempt the field. I mean, that's not part of the statute. But why is it not implied that the state is taking care of this for civil office, and you might be able to legislate this city, you may be able to legislate on different issues, but not for that?
In other words, if I can just add, the state has listed some felonies, but it doesn't say all felonies. The whole world of felonies is out. If you are charged with a felony, you can't do it. So because the state has listed some felonies, does that mean that we cannot that the local law cannot include any felonies? And if it did, it's field preemption.
Absolutely not, Your Honor.
It's preempted field preemption.
Because there's no field preemption, the city can pass laws on this topic. And there's no field preemption because, again, in order to show implied field preemption, you have to show more than just the state has spoken on the issue. There has to be some kind of legislative statement indicating an intent to preempt a field.
So in other words, they'd have to make a statement like, you may not legislate with regard to any felony. You may not have someone who has
I think
any
that would
felony.
be express. Implied could be something like legislative findings about the need for statewide authority in the topic. There's nothing like that here. And what's more, and the second point, Your Honor, is that the state has expressly preserved for localities the authority to set qualifications for local office. That's in the Constitution and in the municipal home rule law. I noticed my adversary didn't point that out at all. But the fact that the state law specifically reserves the right to localities to set their own qualifications for office shows that there's no intent to preempt the field. There's no conflict preemption either. Now, my adversary is arguing that there's a conflict because they're inconsistent, but it's not the standard just because the locality prohibits more than the state, that's not conflict preemption. And the Court of Appeals said that directly in the PBA case from 2003. The Garcia case said that if that was the standard, the power of local governments would be illusory. So we know that localities have the authority to make these qualifications under the municipal home rule law, and we know there's no conflict preemption because the state has not expressly authorized people with these kind of felony convictions of the right to run for office. If the state had, there would be conflict preemption, but we don't have that. I'd also just like to speak on the freedom of association claim that plaintiffs, I think, alluded to at the end of their argument. Both state and federal courts have repeatedly upheld as lawful reasonable qualifications for public office that serve legitimate government purposes. And this is exactly in line with those cases. I would point this court to the Golden v. Clark case, the Rosenstock case from the state court, and in federal courts, we have the very, very similar Torres versus Puerto Rico case from the First Circuit. Plaintiffs have not pointed to any cases striking down any law remotely like this kind of law. And in fact, if their theory was accepted, it would cast doubt on a wide variety of laws setting qualifications for public office, including the very similar Public Officers Law 3-1A, which they also argue preempts our law. So their constitutional theory doesn't hold up, their preemption theory doesn't hold up, and finally, their referendum theory also doesn't hold up because, as the Court of Appeals recently clarified in Facella, this provision of the municipal home rule law that they're seeking to rely on, it pertains to procedures and processes. And this is not a procedure or process, it's simply a narrow, reasonable qualification for public office. It serves a legitimate government purpose. And again, it's in line with many other qualifications for public office, including many like the Public Officers Law, which as far as we know, no one has ever sought to challenge. Thank you, Your Honors.
Thank you.
How much time do I have?
1 minute?
1 minute. So I think the papers are very clear, at least I hope they are. I just want to cite to the PBA case that the Court of Appeals that's been referenced with regard to the necessity of the state law being explicit. It says that a local law regulating the same subject matter is deemed inconsistent with state law if it either prohibits conduct which state law, although perhaps not expressly speaking to, considers to be acceptable or at least does not prescribe, et cetera. In other words, state law doesn't have to state explicitly that we are covering the field. As long as the local law is inconsistent with the state law, where the legislature has continued to fail to include those kinds of crimes that the local law has now promulgated, then we have a preemption problem. With regard to the constitutional issue, every case is different. And the Anderson case lays out that election laws need to be in line with the Constitution. There's always an infringement when there's an election law, always. But if the state or the locality has a rational basis for that, then it's permitted. Well, what's the rational basis here? According to the sponsor of this particular law, it's that somebody who has committed a crime would be too popular and therefore be able to run and win again. Well, what kind of rational basis for the law is that? It doesn't make any sense, really. He doesn't say anything beyond that. And there's no other legislative record. There's no memorandum. There's no other testimony or anything like that. So courts, federal courts and state courts, need to make an assessment as to whether or not it makes sense to infringe upon the voter's ability to choose among candidates based upon what the locality or the state feels is important. And every case is different. So it's up to you to decide whether or not the fact that this particular felon would be too popular and win again, whether or not that makes sense in terms of denying the voters the right to choose.
Thank you.
It's spelled out
I
much
think
more
I've given you well over your 1 minute. I think you've, yeah.
I'm sorry?
I think you've gotten well over your 1
Yes,
minute.
I
Thank you.
know that, and I
Yes.
appreciate that. Thank you.
Your Honor, just two very quick points. The language he's reading about inconsistency, that's from the PBA's discussion of field preemption. If there is field preemption, localities can't pass an inconsistent law. But a mere inconsistency doesn't show preemption in the first place. Again, you need to show either field preemption to begin with or conflict, and they haven't shown that. Second, plaintiffs are really mischaracterizing the testimony before the City Council. If you read the hearing transcript, the sponsor was concerned about corruption and the integrity of the elected offices, and this law serves the exact same purposes as Public Officers Law 3.1-A, the state law, and the same purposes as the law that was upheld in Torres versus Puerto Rico. Thank you.
I
Your
didn't
Honors.
hear the last thing you said,
Oh,
sorry.
it serves the same purposes as the law that the First Circuit upheld in the Torres case, which again is very similar.
Thank you.
Thank you, Your Honors.
Thank you both. Real World versus 393 West Broadway.
Good afternoon, Your Honors. May it please the court, Jackie Aiello for the appellants. This is a 10-year litigation that largely started as a dispute between the parties related to alterations that the plaintiff wanted to achieve in its apartment. And it has since become much more than that. But at the end of the day, after discovery was done in this case, we moved to for partial summary judgment. It was partially granted. In that the breach of contract claim for the wrongful refusal to approve the alteration plan was dismissed. However, the the motion court declined to dismiss the good faith and fair dealing claim, which is identical to the claim to that now dismissed breach of contract claim. The law is very clear that a good faith and fair dealing claim that is based on the same allegations as a breach of contract claim is duplicative and
So
is-
was that, the denial of the good faith and fair dealing claim, was that a result of the fact that the restoration of the mezzanine was denied by the board even after the buildings department had approved the the plans for doing that, and that there was no claim that it would have taken up any further air rights or any other thing that the board was claiming. Isn't that why it was denied?
Yes, and so on that issue, which it goes to both the good faith and fair dealing claim and the quiet enjoyment claim, although it was approved by the DOB, there also is the roof purchase agreement where the parties had negotiated and agreed that there would be no roof structure larger than 600 square feet. And this mezzanine, this pop-up of the roof would have more than doubled that size that was agreed upon between the parties. So the co-op did consider that, and I will point out that the plaintiff's own professional, Frank Bosselman, acknowledges in an email to the plaintiff that that pop-up was a roof structure, would have required.
So what about the Department of Buildings findings? I'm not sure how that, was that taken into consideration? What was the point of those findings?
Well, the DOB did not, I don't believe, take into account whether or not it would be considered a roof structure under the roof purchase agreement, a contract.
It was
between
that the
parties.
restoring the mezzanine wouldn't affect the co-op's development rights.
So restoring the mezzanine and popping up the roof and creating an additional structure on the roof are two separate things. The DOB actually said.
Well, development rights, wouldn't that be the restructure? Isn't that what that refers to?
I can't say that that's what it refers to. What the DOB did say was that they could restore the mezzanine without popping up the roof and creating a structure on the roof. They were grandfathered in. They didn't have to pop it up, but they wanted to, and they wanted to make it much bigger than what they had negotiated in the roof purchase agreement. So because of that, and the fact that it was 1,400 square feet instead of 600 square feet, then that is one of the bases in which the co-op had an issue with the latest plans.
So let me ask, okay, so so you're saying that the latest plans were not before the Department of Buildings?
They were before the Department of Buildings.
So then the Department of Buildings would have been well aware of what it was that they wanted to do. They saw everything that you're talking about now, of what the plan was going to bump up or whatever you're saying. Department of Buildings had that before them. And that's what they said would not affect the co-op's development rights.
But whether or not it affects the co-op's development rights is not, the DOB is not going to get involved in what the parties agreed to in the roof purchase agreement was simply no roof structures under over 600 square feet.
Counsel, I guess the issue, though, is in denying the ability to continue with the construction, in light of the DOB's approval of it, that there was some bad faith in doing that, which would make the claims not duplicative.
And that's why in our brief, we point to all of the 5 years before this happened. From 2009, the co-op had approved an alteration in 2009 that plaintiff decided not to go forward with. Then they submitted another one in 2010. The co-op had approved it. Then they decided not to go through with it.
Well, in approving it, though, were there not impediments put in place to getting the construction going?
As in any other alteration. As in any alteration in a co-op where it is going to disturb the building, it's going to disturb other shareholders, there's always, you have alteration agreements, there are things in place and things that the shareholder has to abide by. And that's
Right, but if there's an agreement that allows the shareholder to do something in particular, the board can't, in bad faith, impede on the shareholder's ability to do that.
No, the co-op cannot act in bad faith. But our point is that the plaintiff says that they were denied in 2014 in bad faith. And our position is there's 5 years of history showing that the co-op was working with the plaintiff, approving different plans that they decided to scrap and move back and forth.
Why aren't the allegations of denial in bad faith not duplicative of the breach of contract claims?
Well, the breach of, if you look at, I think it's the second cause of action that was dismissed, the breach of contract, it is exactly this. It was the wrongful denial of the alteration plans. That's exactly what the good faith and
So
fair
the
dealing claim is.
allegations in both causes of actions are the same?
Identical.
And because they're identical, you're arguing that it's duplicative causes of action?
Yes. I just want to turn quickly to the other two issues, the private roof materials claims. We made a motion for summary judgment on this issue, saying that there were no issues of fact that were raised in discovery. There was interrogatories that we had imposed. We asked what was the basis for the claim that the private roof materials were insufficient for plaintiff's purpose, and the answer was we walked on it. The only other thing that was submitted in response to our motion was Torres's affidavit, which says maybe if I didn't actually see the final materials. He had nothing to go by. And the law is clear that an expert affidavit that is based on nothing but speculation, like Torres's affidavit was, is insufficient to create a question of fact to overcome summary judgment. And I would also point out that
But that's assuming that you met your burden on summary judgment, right? Was there any affidavit from the architect to support your issue?
there wasn't. It's on plaintiffs. It's plaintiffs' burden to lay bare their proof. And what is it? Where is the question of fact? There is not anything that they submitted other than an interrogatory that says we walked on it. It feels soft. So,
Thank you. Ooh. Thank you. Thank you. Have some time on rebuttal.
Good afternoon, Your Honors. Mark Lane for the plaintiff respondent. So many issues and listening.
Counsel, why don't we start with where we started with counsel with regard to the restoration of the mezzanine, and why don't you focus on how the fraud claim that comes into this is different than the breach of contract claim?
Right. So the motion court dismissed the two basic contract claims in the case, which alleged that it was a breach of contract for the co-op to refuse to approve the renovation. This was based on the DOB's approval. Even the co-op's architect approved it. We went through every hoop they made us go through, and it was completely approved. The DOB confirmed this is not a roof structure. It is not an additional floor. It doesn't implicate FAR. So we allege this was a breach of contract for them to refuse to approve it after putting us through all of that and saying they would approve it if we went through all of that. The court dismissed that on the grounds that the proprietary lease gives the board discretion to approve or disapprove a renovation, and therefore there can't be what the court referred to as a simple breach of contract for refusing to approve the renovation. But the court very correctly held that there are issues of fact as to whether the co-op, whether the board abused that discretion in the conduct over a period of now 17 years in refusing to allow the renovation.
What about, so you're claiming bad faith on their part, but what about what counsel said, that it was approved several times and that you scrapped the plans and it kept coming up? I wonder if you could go into that.
Right. As we pointed out, and as the record is pretty clear, that's just simply not true. The co-op has never approved a single renovation plan that the plaintiff has submitted, not once in 17 years. The closest they ever came, there's never even been a board vote. The closest they ever came was when they conditionally approved the plan that is at issue with a long list of conditions that are literally impossible to meet. For example, we need to open up a section above the mezzanine to make the code height. Right. And in order to do that, you have to cut joists. So one of the conditions was you can't cut any joists if you're going to do this renovation. Another condition was you can't increase the electricity beyond what's already in there, which was only 60 amps. At the same time, the board members were increasing their own apartments to 200 amps using co-op funds. So there's a lot of bad faith here, spread over a very long time, and the record is crystal clear that the co-op never approved a single renovation.
So that's why the court left that claim in, even with knocking out the contract claim.
That's correct. I mean, obviously, the same set of facts may support more than one kind of cause of action, and that's not even what happened here. The court held that this set of facts does not support a straight contract claim, but does support a claim for breach of the implied covenant of good faith and fair dealing. There's an extensive record in support of that. I mean, I would also point out, I know you're aware of this, but they moved for summary judgment on a largely factual motion, and they're here arguing facts today without a single fact affidavit from anyone being submitted in support of the motion. We submitted 4 lengthy, detailed fact affidavits, including an expert affidavit and a counsel affirmation, and which, even if all of their submissions had been proper, the plaintiff's response to the motion would still have created issues of fact on these causes of action. But however, they didn't meet their burden. They didn't submit a single fact affidavit on a fact motion.
Could you deal with this issue about the overissuance of shares?
Yes, of course. The plaintiff purchased this co-op. They purchased the apartment and the private roof at the same time in January 2008. They purchased the co-op from the private owner and the private roof from the co-op for $1.2 million. 4 shares of stock were supposed to be issued for the private roof. They were purportedly issued.
But they never existed?
They never existed, and we didn't
So they
discover
weren't
this.
even there to be offered?
I'm sorry?
They weren't even there to be offered. They weren't there.
Correct.
But they said that they would correct that. Did
They
that ever
actually
happen?
Initially claimed that we were outside the statute of limitations when we raised it. We learned during discovery that 3 of the board members had decided they wanted to plot to acquire the private roof for themselves because it's now worth a lot more due to development rights in Soho.
Was the issue of overissuance subject to a prior order?
It's several orders, Your Honor. The motion court referred the issue out to the special referee part, which held extensive proceedings and took a lot of evidence on it and issued a decision rejecting every argument the defendants had made and ordering them to correct the overissuance.
So then the issue of noncompliance with with those orders, is that appropriate in this action, or does another action need to be brought?
It's definitely still appropriate in this action, Your Honor. The special referee, when she issued her decision, made clear this is not a final decision. She instructed the defendants what they had to do to correct the problem and finally issue the shares. They have not done those things, and the shares still do not exist. So the court, after the special referee decision, much later, like 9 months later, the defendants moved to re-argue it, and the court rejected that and directed the defendants to correct the overissuance 9 months after the referee's decision. They still have not done that. They've not even held a board meeting. There's not even been a vote. And we don't have the shares. 17 years after paying $1.2 million, the plaintiff can't even sell this unit because they don't have the shares. We've tried for years. We were awarded $100,000 in legal fees, which are still being incurred because of the defendant's malfeasance in not issuing the shares and refusal to correct it. I'm sorry, I've taken more time than I should have.
Well, you shouldn't apologize. That's why you have the time to use it. Thank you.
Quickly on the issues of the good faith and fair dealing and quiet enjoyment claims and counsel's position that there's never been an approval. Page 896 in the record is where the 2009 approval is. It says specifically that it was approved and that they just needed a room-by-room description of what was being changed. On page 929, that's where the 2010 approval is. It says the board has approved the alteration project going forward at this time based on Richard Lewis's report. They did several times, and plaintiff decided not to move forward with it. Even still, I would
Well,
say—
what about, that's not, I asked him that specific question, and he said, maybe you approved it, but then you put so many restrictions on it that they weren't able to do that.
That
So,
was
I
on
mean,
the
you kind of
2014.
forgot that part.
Their position is that happened on the 2014 alteration application 3 years after, or 4 years after, the 2009 and 2010 alterations had been approved. And the record shows that both of those were approved. And there was not this list of restrictions. In fact, the 2010 approval, it just says, we just need a room-by-room description. Other than that, that's it. So that's not the case, and it's not what the record shows. I would say very quickly on the common roof materials issue, the business judgment rule applies here as well. The private roof materials issue. The business judgment rule applies. This exact issue came up at the lower court, on the common roof materials. We won on this issue with the business judgment rule. It is the very same issue. The court just did not hold the same. And finally, on the overissuance issue, which I didn't get to address, and if the court will indulge me for 20 seconds, the decision was final. It's a hear and determine report. So on a hear and determine report, that decision is done. The trial court, the motion court cannot make any additional changes. There is an order, and by the way, the co-op has not done nothing. It has started an action with against the Department of State. There was a stipulation submitted to be so ordered so that the certificate amendment of the certificate incorporation can be redone. Thank you.
Thank you both. Tahari versus Narkis.
Good afternoon, Your Honors. David Feuerstein of Feuerstein-Kulik on behalf of the appellant, Shlomo Narkis. Your Honors, this is our appeal of decision on the parties' competing motions for summary judgment. In the spirit of Justice Renwick's instructions, I want to point out three things today that I think I'd like to emphasize. First, there's no dispute that Mr. Tahari knew and believed that he was being defrauded in 2006. We have three documents in the record for Your Honors to review. There's two on pages 176.
Hasn't this already been decided by the court, in our court, that in fact, he did not have notice until 2019? Hasn't that been decided?
Your Honor, the decision that came from the First Department was on a motion to dismiss. That was obviously a point in time when you had to accept the plaintiff's allegations as true. Not all of the documents and not all of the evidence and no deposition discovery had taken place at that time.
But the court was aware of that at that time, and I thought that the prior appeal established that the fraud claim was not barred by the statute of limitations. That was one thing. And that Tahari is the real party in interest, not his company.
Right, I'm arguing on the inquiry notice for the fraud point, Your Honor.
Okay.
Which was so on the fraud point, he said the point was that there were letters before Your Honor, but those letters arguably had some ambiguity.
But I mean, I'm looking at the First Department case from 2 years ago, and the court didn't say, well, at this time, this is our determination. They said it was not until July 2019 when defendant averred in an affidavit that he did not actually need or use the $9 million. So that was the fraud. So they didn't know about it till then. They didn't say maybe if other information comes up, we'll change our mind.
But Your Honor, they did know. My point is they did know about it in 2006. And if you look at the documents that were occurred in 2006, which were elicited through discovery, what you see is that he said, I didn't think that at 2006, maybe the money wasn't being used for the reasons you told me. In fact, on page 806 of the record, there's a draft complaint that was sent in 2006 from Mr. Tahari's counsel where he says the loan, I believe I'm being defrauded because the loan was not intended to help his cousin. It's exactly what he's saying. And the question is not whether he knew every specific fact to substantiate the fraud. The question is whether he was on sufficient notice such that the statute of limitations would continue to run. And that's all we're arguing, Your Honor, which is that he had sufficient notice in 2006 such that he cannot say that he discovered things.
Just about that, because the documents you're referencing, did they exist at the time this court's order came out?
They did exist, obviously, Your Honor, because they were issued in 2006, but it was on a motion to dismiss, right? So it's not a summary judgment motion when this court was reviewing the record the first time around. I'd also say, Your Honor, that the way the court below got around these documents was that the court said, look, the fraud that was being discussed in the 2006 letters was this idea that there were promises or representations that you would sign or enter into an agreement.
To pay the money back, right?
Well, to enter into agreement to pay the money.
Right.
But that's not anywhere in the record. So if you look at page, for example.
But the particular fraud being alleged now is that the money was going to be used to prevent him from remaining imprisoned, right? To put within a summary of net worth, right?
That the fraud was that he was going to help him get out, help him with his plea agreement to shorten his prison sentence. Correct.
Right. That's what's being alleged, and the only indication that fraud was now known to Mr. Tahari was based on that affidavit from 2019.
I disagree, Your Honor, respectfully, because in 2006 he sent a complaint, and what he says in this complaint, I'm reading from it, he talks about that Mr. Tahari contacted Shelley asking to get the loan money back. Since Mr. Tahari did not receive the loan money back, he began to suspect that the loan was not at all intended.
But who is saying, this is,
This is Mr. Tahari's lawyers on behalf of Mr. Tahari.
okay.
That to help his cousin return to the straight and narrow, repay his debt, and save him from his actual imprisonment. So in 2006, he's saying, I'm suspecting this. And what the cases in First Department says, if you have this suspicion, this underlying suspicion, you're at least on notice. I'm not suggesting that the statute of limitations had to run from 2006 and there was only 2 years left. I'm simply suggesting that the inquiry notice didn't begin in 2019.
Thank you.
Good afternoon. May it please the court, Marie Matthews for plaintiff respondent.
Can I ask you something? I mean, didn't we make this determination, the appellate division 2 years ago, that inquiry notice didn't start running until 2019? And it's like you're trying to re-argue our decision. I don't think that you can decide that, well, that's what the appellate division knew now, but now we can bring in additional information. So I wonder if you could deal with that, because I'm confused.
Yes, you're exactly correct. The letter that Mr. Feuerstein has been relying on to argue that the statute of limitations has run is the same letter that he relied upon at the motion to dismiss stage, that was rejected by the trial court, rejected by the First Department, and once again rejected by the trial court on the summary judgment motion. Now, of course, he's correct. That was a motion to dismiss, but again, they're not coming forward with any new facts to say that the First Department's interpretation was wrong at the time, and now we know because here, look at these facts. The 2006 letter that was just referred to and the complaint that was just referred to, those were in the record and those were argued at the time, and they were both rejected because they don't actually support the position. At best, they suggest that there was some potential that Mr. Tahari had been defrauded because his cousin had said, I'm going to pay you back within a year, and he never paid him back. The fraud that was actually pled and discovered in 2019 is that in 2005, when he asked for the money, he said, I need this money to get out of jail right away, send it by Monday so that I can satisfy my plea bargain and get out of jail. No one had any knowledge that that was a fraud until 2019 when Mr. Narkis filed an affidavit in the Israeli court that said, no, I didn't need it for the plea bargain. I didn't need it to get out of jail, but I told Tahari that because I wanted to incentivize him to send me the money. That was what put us on notice of the fraud. So you're right, that has been decided 3 times already, and we don't have any new facts that would change that analysis that have come out in discovery. Thank you.
Were there any new facts that came out? Yes, there are new facts that came out. In fact, Mr. Tahari was deposed, and he was asked the
But counsel, right now, you were relying on a letter that was before the court when we decided this back before.
I understand that, Your Honor, but there was at least the letters themselves, in our view, state exactly that there was at least some suspicion that there was a fraud, and that suspicion.
But there was a suspicion that, I don't know that, I think that's where you're saying that there's a suspicion that there was a fraud, but all he knew was that he wasn't getting his money back. He didn't say, I now know that I wasn't getting my money back because he really didn't use it for jail.
Well,
that didn't come out till 2019.
Well,
He
again,
was
Your
just saying that, well, I'm not getting paid my money, what's going on?
Actually, Your Honor, I think the quote that I quoted earlier with respect to the complaint indicated that he thought it was being used for ulterior means, and I'd also note that
we had that when we made the previous decision, right?
I believe you did, Your Honor.
No, we did.
So then I understand that, but I'm saying that there's also deposition testimony that comes out afterward, so that you can have, right, at a motion to dismiss, you have to have conclusive proof at a motion to dismiss in order to agree that that letter is sufficient to deny a party discovery. Now we're at summary judgment. Now this question at summary judgment is there a material factual dispute between the parties with what the letter says? And I think that letter, fairly written.
Well, what new information has come to light after having that letter to say that it's conclusive that there's no dispute as to the issues?
Because there's been no alternative offer meaning that's been provided by Mr. Tahari as to what that letter means. Because at his deposition, he never said, oh, you know what this letter really means is that I thought you were going to come to me and you were going to promise to sign an agreement, and you didn't do that. That's not what he said.
It was your motion for summary judgment,
It was
right?
competing motions, Your Honor.
Right,
but
but
that's right.
with regard to the fraud.
That's correct, Your Honor. And so ultimately, let me finish one point with it. In the letter itself, the letter itself says at the very end that Mr. Tahari is extremely upset that he must resort to legal proceedings to recover these funds, considering the various individuals involved are close family members who he believed, apparently incorrectly, he was helping out of a crisis. Right there, he says, I thought you were using the money for one
Helping
reason.
out of a crisis, like you were in a jam, you needed the money, so I
Get out
gave
of
you
jail.
the money
Yeah.
really quickly.
That's exactly, on page 20 of their brief, Your Honor, that's exactly what they're saying the fraud is that we told them that the money was to be used out of jail, and it wasn't. So we're saying they knew what it was.
It doesn't say that they knew.
By saying crisis, they knew what it was. It didn't need to say it inside.
But it says there's more to it in the letter. If you look ahead of the letter, it talks about the fact that there were ideas of shortening down his plea and getting a lesser term in prison. So the whole letter as a whole, when you read it, and you hear Mr. Tahari's testimony, you read Mr. Tahari's testimony, and you see that he's not saying that it's about this idea of a fact that he'd sign an agreement. It has nothing to do with signing an agreement. That was something that was concocted on the stand during all our argument below.
Thank you.
Your Honor.
Thank you both. People versus Rudy Ozias.
Good afternoon, Your Honors. Will Page, Office of the Appellate Defender, on behalf of Mr. Ozias. Mr. Ozias is asking this court to reduce the sentence on his gun charge so that it's in congruence with the sentence on the manslaughter charge, so that he'll have a meaningful opportunity to be released and to be reunited with his family and his young children who are particularly in need of him at this critical stage of their development. Now, Mr. Ozias has always accepted full responsibility for the events here. There's no question about that. The prosecutor acknowledged it below, that no one doubted that he did not intend to harm anyone, but that the consequences of his actions led to this tragic event. And Mr. Ozias said as much at sentencing when he turned to the victim's family and he apologized from the bottom of his heart, and he said, there's nothing I can do to bring your daughter back, but I'm sorry, and this is something I have to live with for the rest of my life. He's also described that as a stain on his soul. And knowing Mr. Ozias, I know that that's something that he will carry with him. But right now, as it stands, the manslaughter sentence is 15 years, and is 5 to 15 years, but the gun sentence is 15 years. So that means he has no chance at demonstrating that he is, acclimated to incarceration, that he's doing his programming and achieving parole.
The sentences are running concurrent, right?
That's correct. And so if this court would reduce the gun charge sentence down towards the lower end of the spectrum, then that will provide him with that meaningful opportunity to reconnect with his family and to be there for his children. And as his family has described it in the pre-sentencing memorandum that was submitted, which hopefully the court has in its records, but if not, happy to provide it, his children are a grounding force for him, and they altered his life materially. It is through the birth of his young daughter and later his son that he learned to grow as a man and become responsible. Now, obviously, again, we're not minimizing his tragic lapses in judgment here, but we are asking that the court look past the appeal waiver and reduce his sentence so that he'll have a chance at parole. Speaking just a little bit to the appeal waiver. Oh, Your Honor, were you going to ask a question?
Yeah, go ahead.
Speaking to the appeal waiver, Mr. Ozias' relative inexperience with the criminal legal system, in fact, these were his first 2 felony offenses, is part of the reason, part of the totality for why the waiver should not stand here. The colloquy itself was also somewhat unclear, and it was never clear to Mr. Ozias, as demonstrated by his pro se 440-20 motion, that he could not seek the mercy of the court or seek a reduction in his sentence. Now, I do know that the court eventually got there, but here, he was confused by it. And that's, in particular, the court had actually had him already allocute to his guilt before it ever got to the part where it said, and now you're waiving your appeal. The court also never checked back in to see if he understood the full waiver of appeal, which he signed. And you'll note that there is a written waiver, but it doesn't explicitly mention excessive sentences. And so, again, I think the appeal waiver should not be an obstacle here to recognizing Mr. Osias for the man that he is, the man that he has the potential to be, and allowing him that meaningful opportunity to reconnect with his family.
Thank you.
Good afternoon. ADA Mallory Phelps for the people. Defendant waived his right to appeal this issue. Further, his sentencing is not excessive given the serious nature of this crime. If there are no further questions, I
Well, I
rest
do
on my
have a question because counsel is indicating that the appeal waiver is invalid because the court went through the appeal waiver after the defendant had already pled guilty. What's your specific response to that?
Well, that is true. However, this court has repeatedly found that that doesn't make a waiver invalid, especially because in this case, the defendant had talked to his lawyer about the plea, had signed a written waiver, and the court correctly explained his rights. If there are no further questions, I rest on my brief. Thank you.
Counsel, are you only asking us to reduce the sentence for the criminal possession of a weapon charge?
Yes, that's right, Your Honor.
So would that be to 10 years? Would be
Somewhere to the lower end of the spectrum would be maybe 7, I think, would be allowable. Somewhere that would make it so his 5 to 15 on the manslaughter, obviously the more severe charge, would be controlling here. And
What is the range for the weapons charge?
sorry. He pled to the maximum.
I believe it's 15.
Minimum is 3.5.
The minimum was 3.5. That's correct, Your Honor. And so making the manslaughter charge control, he's pled to 5 to 15, then that will give him a chance at parole. And so in closing, I really would just say,
So on the manslaughter, it's 5 to 15, and on the,
weapons, it was 15.
it was 15.
Yeah, he received the maximum. And this court is well suited, obviously, to look at global sentencings and dispositions here and correct an injustice of this magnitude. Thank you.
Thank you. Thank you both. Patel versus Maybank Kim Eng Securities.
Good afternoon, Your Honors. Don Abraham from Bronster LLP for the appellant Ankit Patel. Your Honor, what my client seeks to do is to reinstate his second cause of action for labor law violations, which is in addition to his breach of contract claim for not being paid 2 months' worth of wages and or severance pay.
Was he entitled to it under 198-C?
Excuse me?
Was he entitled to that, to those wages under 198-C?
198-C, in our position is that 198-C was a prior it really deals with criminal penalties that are associated with labor law violations and don't give rise to a civil action. And there were definitions that were incorporated into Section 190 of the labor law statutes that were in the past misinterpreted to mean that there was some sort of limitation on employees to being able to pursue a labor law claim if they made more than $900 a week.
But it also, it indicates executives, not employees.
Oh, executives or somebody who was highly paid or an executive that made more than $900 a week. But that was all abrogated in 2021 when the legislature came out with the No Wage Theft Loophole Act, where it made it clear that the right to sue under the labor law, 198.3 specifically, actually, they tried to harmonize 193 and 198, and they said it applies to all employees without any exceptions, and it applies to wages, benefits, and wage supplements. So there were no exceptions to that.
But
And this
counsel,
court,
section 198C was not abrogated by the legislature.
no, it wasn't abrogated by the, no, that wasn't abrogated, but the idea that the limitations of under 198-C, that those limitations applied when you were seeking a civil remedy under 198 or 193, that you're somehow limited or you didn't have a right to sue because you made more than $900 a week was not applicable. It was
So
abrogated.
your argument is that the limitations apply specifically only to the section that it's in.
That's right. And as a matter of fact, this court, Your Honor, in New versus Amelia, which just came up in April of 2024, found exactly that. There was somebody making over.
But isn't that case distinguishable from your case?
No, it is not, Your Honor. That case dealt with wages and wage supplements. Both those issues were addressed, and this court
But
decided.
the finding was that it dealt really with wages, not wage supplements.
No, well, that's not true. The court didn't distinguish when it made its decision between wages and wage supplements. In that case, the court said it made its decision just saying wages, but there was an issue in the underlying case whether it was wages or wage supplements.
But we knew how to say wages and we knew how to say wage supplements, and we said wages. And here, they're clearly wage supplements.
Well, it's not clearly wage supplements, Your Honor, as well, because under the expressed allegations in the complaint here, okay, when he was terminated.
He pled, these are wage supplements. That's
Not
what it
exactly,
says.
but we also pled in the complaint. If you look at the amended complaint in record R139.
But counsel, what exactly are we talking about? We're talking
I'll-
we're talking about severance pay, right? We're not talking about
No,
payment.
not necessarily. I'll tell you why. Because when he was fired, he was entitled-
Am I allowed to
to as-
finish my question?
Oh, I'm sorry.
I
go
did say, I said supplements, I meant severance, thank you.
ahead. It was.
There's a question here.
Yeah, go ahead. I'm sorry.
Now
This
I've
is my
forgotten the question.
It was about the severance, it's maybe,
So it wasn't when he was terminated immediately. He was entitled to 2 months notice. He didn't get that, and they paid him immediately the 2 months on the date of his termination, which was the date he got fired. After that, okay, he had a separate severance agreement, where he was entitled to get. He was supposed to get 5 months, but they said that the 2
Right,
months.
but that's a supplement. That's not payment for the work that he did. He was already paid.
It was part of it. It was actually no, because if it involves the 2 months that he was paid, that they're saying was part of the severance, that means he's really suing in effect for and at least there's an issue of fact on that, for the money he didn't get on the notice, being fired immediately and not getting the 2 months worth of notice when he was fired immediately.
well, that's not what he,
But he was paid for those 2 months.
No, but not if they're saying it's part of the severance. So that means he really was part of the employment agreement that said he was entitled to 2 months notice, which he didn't get.
But what's left now in the severance agreement, if you subtract the 2 months from when he didn't get notice, is just supplements, just wage supplements from the severance agreement.
Right, but if he's
Right.
well, no, but if he's saying
no, I think you said right.
no, I'm just acknowledging what you said. You can't have it both ways. If you're saying that the severance agreement said 5 months that you're entitled to, but it didn't include the 2 months. That's expressly stated in the amended and alleged in the amended complaint, which says it's either one or the other. So if you're saying the supplement, the severance included the 2 months you should have gotten from the employment agreement, and you didn't get it, so then essentially.
Counsel, I think it's your client that can't have it both ways, right? Because he's suing on a severance agreement, which, for all intents and purposes, has been pled as wage supplement, not as actual wages, right?
Well, yeah, and by the way, in our view, I don't think that matters. I think you cite in the New versus Amelia case 198.3, and you cite the Patrick case to say whether it's wage or wage, because 198.3 talks about wages and wage supplements and says there are no exceptions, whether it's wages, wage supplements, or benefits. They made it clear on that issue. So I don't think that matters whether or not it's wages or wage supplements. I'm just saying, even if you go to that distinction, which you never made in New, and that issue came up in New, but nobody ever said it, we're just talking about wages and not wage supplements. It wasn't an issue, really. It was just an argument that was made.
Thank you.
May it please the court, Michelle Coyne for respondent defendant Maybank. So several of the points that I wanted to raise have already been raised thus far in the argument. You're absolutely correct. The new case was about wages. It does not cite to 198.c, which is where the wage supplement is defined and where the exemption exists for executive, administrative, and professional employees. The notion that in amending 193 and 198, separate provisions, that somehow does two things, which is one, also amends 198.c, and two, somehow makes that provision just limited to criminal liability, which is not how it's been interpreted, has not been interpreted that way by this court.
I guess it's disconcerting because in that No Wage Theft Loophole Act, they add a new section which does say there is no exception to liability under this section for the unauthorized failure to pay wages, benefits, or wage supplements, and that there was no, it's a confusing thing that the legislature did, but there's no way it could be interpreted to cover this. I mean, aren't they somewhat in conflict now?
I don't think there's a way to interpret it that way, Your Honor. First of all, if, as counsel has argued in his papers, that all means all, and therefore just saying all abrogates an entirely different section, well, surely there would have been no reason to add that same language to both 193 and 198, because saying it once would have been sufficient. But that's not the case. And as cited in the legislative history, the legislature was getting at other issues. It was not about 198-C, and that there's just no argument. That provision.
In fact, since 2021, 198-C has been amended in terms of the monetary amount. So if they wanted to amend it further, they could have, but they did not.
A very good point, Your Honor. Thank you. It has been amended in terms of what that monetary amount for which the exemption applies. Thank you.
I'll be quick. Just to get back to the issue on the supplements, the legislative findings that we produced and then we cited to before the lower court were fairly explicit, where they, basically the intention of the legislature. I know they were trying to harmonize 193 and 198. The intention was very clear. It was supposed to make it so there were no exceptions if an employer promised something to an employee, whether it was a wage, whether it was a wage supplement or a benefit, there were no exceptions. In the act itself, the Senate bill actually references this. There's a law review article that talks about the misunderstood nature of 198-C, and this is all in the legislative history, so it shouldn't make a difference, and I think that's what the decision of this court in New was actually stating.
Thank you. Thank you both. Gamma USA versus Pavarini McGovern LLC.
May it please the court, Michael Catania from Catania Mann and Ryder on behalf of the appellant. Yeah, one of the things I really wanted to highlight for the court today is the threshold issue below that, again, we're dealing with a motion to dismiss where you have the only evidence submitted is a contract document.
So this is for delay damages, right?
Correct, the delay damage
the
claim.
main issue here. And it seems that the section 6.3 of the subcontract with Gamma provides that notwithstanding any other provisions of the subcontract, the Gamma agrees to make no claim for additional costs. How do we get around that language? I mean, when you have that notwithstanding claim, how do you get around that to get to the claims that you're trying to?
Very simply, Your Honor. So the CMA, Construction Management Agreement, is a contract document. It's fully incorporated, not just as to scope. It has a clause in it relating to delay damages and the ability of the respondent to recover even for its own delays. And that clause says, notwithstanding anything else in this contract. So how many notwithstandings can you have in a contract? Do they cancel each other out? I mean, you have a situation where you have at least three no damage for delay clauses in the subcontract. And there's no dispute as to that, and there's no dispute that if there is an ambiguity or a conflict in any of the provisions in the contract documents, that the motion below should have been denied. The dispute is whether or not there's a conflict between the provisions. And as I laid out in my brief, and I think, frankly, if I could just highlight one example of it, you have the respondent, on the one hand, as you said, notwithstanding an absolute bar of all claims, not just as to Pavarini, but the owner, the architect.
Overriding everything.
Yes. Then you have in section 14.A of the subcontract, this is the provision that allows the appellant to, through PMJ, submit claims in good faith to the owner. Respondent's brief on page 24 states that this is true to an extent, and goes on to say, but 14.A clearly does not permit Gamma to pursue the delay damages it seeks in this litigation, i.e. delay damages against PMJ. That is simply not true. There's nothing in that provision that states that. So PMG has the ability, in its agreement with the owner, to recover delay damages, whether they're framed as unforeseen conditions or uncontemplated delay. They have that ability. So the section, as far as that it prohibits Gamma from claiming any delay damages against PMJ is just simply incorrect. And it's inconsistent with not just that provision, but all the other provisions that I pointed out in my brief. That's the threshold
So that would
issue.
mean that the notwithstanding clause is meaningless.
So, but then that would mean that the other notwithstanding clause is meaningless, right? So, and especially at this stage, to me, it creates at least an ambiguity at a motion to dismiss stage where I don't see how you can determine the party's intent at that stage without having had discovery. I mean, this is one of the biggest projects we've had in quite some time. I have to jump quickly to the delay portion, if I may. So that's a threshold issue, and then obviously we've alleged certain exceptions to Carino. The key one that I just wanted to hone in on is, and I just don't think the lower court appreciated it. There is unlike a lot of the cases, both from this court and others, most of which are summary judgment, but that deal with delays. Here you have actual contract documents that talk about what was anticipated as to the delay. You have a 6-month slide. You have provisions that state anything after that, you're going to have $10,000 a month for storage fees. Why would you put in that provision if all delays were incorporated into that no damage for delay clause? So that's on the issue of whether the delays were contemplated by the parties. Finally, just we raise other issues, but the issue of the loading plan, the site logistics plan, that's a huge issue, and I'm not sure if again at this stage it could fully be appreciated by the court below. You're talking about changing. Okay, again, this is a contract document that the bid was based on.
Changing the location.
From 7th, to 7th Avenue, which completely changed the way you can haul these massive panels. Sorry, Your Honor. Thank you.
May it please the court, I'm Brian Waller, and I'm here on behalf of Respondent Pavarini McGovern LLC. The subcontract between Pavarini and Gamma contains no less than 4 separate and unambiguous provisions, no damage for delay provisions, specifically waiving any delay damage claims. These are the exact types of provisions that this court has routinely upheld on motions to dismiss at this stage of the litigation. Gamma and Pavarini are highly sophisticated business entities who expressly contracted to waive any delay damage claims by Gamma against Pavarini. waivers that are standard business terms in construction contracts.
Council says that they're canceled out. There's so many, there are 4 or 5 notwithstanding clauses, they cancel one another out for these
Well,
purposes.
Okay, as Your Honor pointed out, the 6.3 says that no damage for delay clause trumps any other provisions in the contract. But even if you want to look at what he brought up, which is section 14.A, that is not a provision that gives Gamma direct claims, delay claims against Pavarini. It allows for a pass-through from Gamma through Pavarini to the owner. But he's acting as, he's saying basically that because the prime contract has been incorporated into the subcontract, that now you also get to change the language, right? It doesn't say 14.A that Gamma has a right to bring delay claims against Pavarini, so there's no inconsistency. I don't really understand what he's arguing is the inconsistency. The fact that the prime contract allows Pavarini to seek delay damages from the owner doesn't mean that because we're allowed to seek them from the owner, that once it's incorporated into the subcontract, now you get to change the language and say that Gamma has a right to seek delay damages from Pavarini. There's no contradiction here whatsoever. So he's really looking at some very, very clear and unequivocal, there's 4 of them, waivers of delay damages, Gamma's delay damages against Pavarini, and he's looking for a little loophole, right? These are sophisticated businesses who specifically negotiated this term, and now they're asking you, Your Honors, to renegotiate that contract and allow them to have damages that they expressly waived in their contract. So I don't see anything here, even what he's saying here. 14A doesn't seem to apply there. I mean, I think it's clear as day. He's looking at it.
Thank you.
Okay.
I mean, I don't mean to stop you, you do have
No,
some
but
more
I think-
time,
I
but
mean,
you
I think
don't
I've
need to
addressed
go
the
on if you're done.
that he raised.
Okay, thanks.
Your Honors, nowhere in 14A does it prohibit appellant from passing through claims that are a result of Pavarini's delay. Nowhere is that in that clause. And that's not just the only clause. I mean, we've pointed out about 6 or 7. It's not that I'm saying there's 4 no damage for delay clauses so they cancel each other out. I'm not saying that. I agree that they're there. What I'm saying is that you have to read it in the context of the whole corpus of the contract documents. And when you do that, for numerous reasons, there is at least a ambiguity in the fact that they weren't absolute in their prohibiting Gamma from collecting delay damages, as shown by things like the acceleration agreement, as shown by things such as the pass-through, as shown by 3 other examples that we have in our brief. And again, it's at a motion to dismiss stage, and we are looking simply at this contract. And if respondent talks about gleaning the intent of the parties in their brief, if you have to glean the intent, to me that means it's not clear and unambiguous. Thank you.
Thank you. Thank you both. People versus James Rackover.
Good afternoon, Your Honors. May it please the Court, Marika Meese, on behalf of Appellant James Rackover. Excuse me. I'd like to focus on the trial court's decisions, the evidentiary rulings that deprived Mr. Rackover of his right to present a defense and to a fair trial. While the standard for review of those decisions is abuse of discretion, it is circumscribed by my client's constitutional rights. Turning first to the statement against penal interest, Mr. Rackover had offered his co-defendant's statement against penal interest that he had started a fight with the victim and had punched him and body slammed him until he was unconscious and having trouble breathing. And the defense offered that as a hearsay exception under the rule, a statement against penal interest. That rule in and of itself accounts for the fact that there may be other portions of a statement that are inculpatory, but because those are not reliable, they do not come in. So the rule in and of itself accounts for this rule of completeness kind of argument, and it requires a court to have to carefully parse every portion of the statement and decide which portions of that statement qualify under the rule and which do not. By conditioning the admission of that statement in allowing the people to then admit the remainder of the statement and portions that would have inculpated Rackover, my client, the court's ruling swallowed the very rule that allowed this evidence to come in. And it turned on reliability. There was no reliability, as the case law in Bresnik from the Court of Appeals and other jurisdictions makes clear, in the self-serving testimony that implicated my client. So the court's ruling ran afoul of the evidentiary rule and would have swallowed the rule entirely. As well, there's a constitutional implication.
Does it matter that this statement by this person was made completely at the same time, not that he parsed out, said one thing one day and then said another thing another day?
Well, in fact, there were a series of statements made over the course of 3 occasions to different people, but I think it could be parsed that there were statements where he implicated himself and described what happened. And
But the
then,
statement that you were seeking to introduce is what we're focusing on. Was that statement in its totality being sought to be introduced, or were you parsing through?
No, it was portions of his statements, but just to be clear, Ms. DeLeon, the co-defendant, had made statements at 3 different occasions, and the defense sought to admit the parts that supported the defense and show that DeLeon alone had started the fight with the complainant and beat him up.
Right, but the other part of the statement that the court was looking to introduce, was that made at the same time as the statement that you were seeking, that Mr. Rackover was seeking to have introduced?
Yes, there were portions made at each of the 3 occasions that, at least 2 of the occasions, that also implicated Mr. Rackover. But that's exactly what the rule requires. The statement against penal interest rule requires a court to parse out which portions of it fall within that hearsay exception.
The court has a responsibility not to allow something that's going to mislead the jury. And it was clear that the other defendant wasn't going to testify, and that evidence hanging out there would have misled the jury. So it would have made it seem like it was started by the other person, and that was the end of it.
Well, Your Honor, here what's really important is that the defense offered to make it clear to the jury that that was not DeLeon's complete statement. And even more so, they offered to tell the jury that, in fact, DeLeon had made statements that implicated our client, just without giving the precise details of that statement. That surely would have cured any chance for misleading the jury. And you can't use the rule of...
The concern that you have is about reliability of the statement. So is it more reliable to have sort of this ambiguous, amorphous information presented to the jury versus the complete, exact statement of what was said?
It is in this case because the defense was using it to present their defense. They had a defense that DeLeon alone had caused the murder, and they should have been able to present that evidence.
So the
to
reliability
jury.
is premised on what's helpful to the defense and not the complete totality of the statement?
And that's not exactly what I'm saying. I'm sorry, Your Honor. It's not that you look at the reliability in whole. The only admissible portions of the statement were those that were reliable, because those were the ones where he was making a statement against penal interest. The portions where he implicated my client were both unreliable, and they were circumscribed by my client's constitutional rights: his right to present a defense, his right to a fair trial, and his right to confrontation. Neither the rule of completeness or door opening can greenlight constitutional violations and allow what would otherwise be absolutely inadmissible testimony to come in. And because the defense offered to make it explicit to the jury that statements were made, even implicating his client, our client, but those were without the actual content of it, that would have sufficed to cure any potential misleading of the jury.
With regard to the confrontation rule, was that issue preserved?
I believe so, Your Honor, based on the totality of the papers that defense counsel submitted that did rely on Supreme Court cases that talk about confrontation and that talk
That
about
issue with regard to completeness been before was there a case to support that? A federal case to support the idea of when the statement is coming in for purposes of completeness?
if you're talking about like Hempel, for example, is that what you're talking about?
As
Yes.
far as the preservation?
Right. For preservation, I mean, I think it's a close call. I am certainly under the Vidal rule of certainly putting the issue before the court. I think there's enough there for this court to find that it was preserved. In any event, this court, of course, has interests of justice jurisdiction. And on an important issue such as this, I would ask the court to exercise that discretion and view the issue under the constitutional confrontation issue as well. I would just like to turn very briefly to the, and I also just on the misleading. It was in fact the prosecution that capitalized on the court's ruling and misled the jury in summation by arguing, contrary to the statements DeLeon had continuously made, that it was my client who started the fight for no reason and my client who had beat him up and knocked him unconscious, knowing that the co-defendant had in fact made multiple statements saying he alone had done that. So if there was any misleading of the jury, it was done by the prosecution.
Is there an objection to that?
No, but I'm not specifically, I'm not raising that as a point. I'm just showing how the way it came in fact, further made this trial unfair for my client. Just turning very briefly to the 440 motion point on the Colville issue. The hearing court, the court below never granted a hearing, and there were issues of fact as to whether, in fact, counsel had used their own professional judgment. And the court clearly applied the wrong standard. It analyzed this as ineffective assistance. It talked about it being a reasonable strategic decision that was supported by the defense theory and prejudice. And those have no applicability to a Colville issue, which is solely on whether there was a delegation of a decision-making to the client.
Good afternoon, Your Honors. Sylvia Wertheimer for the people. The statement that defendant wanted to introduce was part of a single continuous narrative, the thrust of which was that this defendant, Joey, alone had killed the victim. There can be no serious doubt that it would have been misleading to have introduced only the statement that that DeLeon admitted that he assaulted the victim, because that would have left the impression that the defendant, that he said nothing at all to implicate the defendant.
What about counsel's argument that they were willing to balance that by saying that, make it more complete?
There was no other way to have alleviated the misleading impression here. The notion that he could have, that the defense counsel said he would elicit that DeLeon made other statements implicating defendant in subsequent unspecified misconduct. That would have been entirely inadequate here because defendant's whole defense was that he committed subsequent misconduct. He said that he committed, that after the murder, he cleaned up the apartment, helped throw the body out the window, drove the body to New Jersey. So to say that he would that he committed other unspecified misconduct could have been just understood as that. It would not have cured the misleading impression that DeLeon said nothing to implicate defendant in the murder.
Counsel, if you could just address that particular issue of misleading in light of Hempel, which your adversary relies on.
Okay, in terms of Hempel, first, I believe that the preservation is not just a close call, this is unpreserved. There is no, the defendant below never cited the confrontation clause in support of the argument that the additional parts of DeLeon's statements implicating defendant were inadmissible. He cited it only once in support of his affirmative argument that he had a right to present a defense pointing to DeLeon. He never said anything about cross-examination. He never said he didn't have the right to cross-examine DeLeon. He never mentioned Crawford, which had been decided a long time. The confrontation clause in the papers was mentioned as part of almost a kitchen sink reference of several different constitutional provisions, including due process and the compulsory process clause. So I'd say that it's entirely unpreserved. On the merits, Hemphill was addressed to the opening the door theory. Hemphill expressly left open the possibility that there might be a different result with respect to the rule of completeness. There is good principled reasons why that might be the case. For one thing, the rule of completeness was recognized as a common law exception. Hemphill itself refers to it as that. The opening the door theory was not. The rule of completeness is a much narrower theory, although it shares the common concern with not having a misleading impression. It's directed only to statements by a single declarant made in the course of a single continuous narrative. Hemphill was concerned about this wide-ranging analysis by the courts of different pieces of evidence. That's totally different here. And also, the opening the door theory could not be covered under the implied waiver theory, which the rule of completeness could. So if this claim, the constitutional claim, were preserved, there would be good reason to say that the result here should be different. But I have to say that this is a case where you should not reach this claim in the interest of justice. I would just say at the end, in the end, what happened, of course, is that nothing came out. So the defendant didn't elicit this statement. The jury never heard DeLeon's additional statements implicating defendant in the crime. So he was not prejudiced in that manner. The only harm defendant can claim is that he did not get to introduce the statement that DeLeon assaulted Joey. Well, that suggestion that DeLeon killed Joey on his own would have been negated by the other compelling circumstantial evidence that showed that they did it together. So this is not a case where we should reach an unpreserved claim in the interest of justice. And in addition, any error in terms of the state evidentiary law or constitutional law would be harmless. I do note that even in Hemphill, after the case was remanded, the Court of Appeals held that the confrontation clause error in that case was harmless. With respect to the 440, I don't know, would you like me to address the 44010?
You can just take a...
I just say that the court decision addressed the key issue, which was the court said that the papers showed that this defense counsel exercised a reasonable professional judgment in deciding not to request a lesser included on manslaughter. And indeed, such a lesser included instruction would have undermined the defendant's whole defense, which is that he had nothing to do with killing him, and that it was all DeLeon. So perhaps the judge maybe used the wrong terminology. It was part of a larger motion, which dealt with a lot of other ineffective assistance claims, but the court absolutely decided, when he said that it was a reasonable exercise of counsel's judgment, that indicated that it was not counsel just deferring to the defendant, but that counsel himself independently thought that was the right thing to do.
Thank you.
We ask that the judgment be affirmed.
Thank you.
If the rule of completeness permitted the people to always then just get in the remainder of a statement, the statement against penal interest exception would have no basis at all. It is a specific exception that only allows the reliable portions to be admitted, and the court agreed that exception applied here and allowed the defense to be able to admit. And when the defense then said, we're not going to mislead the jury, in fact, we're willing to say that the De Leon also made statements implicating us, just without giving the full details of that, that was going to cure any potential misleading. The court's ruling instead violated multiple constitutional rights, and you have to look at it in totality. And coupled with its other rulings, including on reverse Molyneux and consciousness of guilt. So there were multiple rulings the trial court made here that the defense challenged them cumulatively that gave the prosecution an unfair advantage in this case that was a circumstantial evidence case. And as to the murder, there was very little evidence. So for those reasons, and on the, I'm sorry, on the constitutional issue, the confrontation issue, the rule of completeness cases that suggest that somehow an implied waiver would permit the rule of completeness to not violate the confrontation rights. The Hempel did not hold that. They didn't squarely hold that or not hold that. No other cases held that.
It was mentioned in the concurrence, though, right?
I'm sorry?
It was mentioned in the concurrence.
It was mentioned in the concurrence, but I think the idea of an implied waiver would never happen in a case where you're asking for a portion of a statement that supports the defense. So you're not waiving your objection to those portions of the statement that are impermissible, unreliable, and that are prejudicial to your client. So there's no implied waiver that could possibly be envisioned in this scenario, in this case. And I will rely on my brief for the remaining arguments. Thank you.
Thank you. Thank you both. McCann versus Shipwrecked Bar.
Good afternoon, Your Honors. May it please the court, my name is Daniel Schneider. I'm from the firm of Offit Kerman, and I represent the appellate in this matter. This application for de novo review to hold the defendants to their bargain accountable for a violation of the stipulation of settlement in this case is a simple matter of the right to contract by sophisticated business owners and contract interpretation. It is our position that the Supreme Court permitted the defendants to rewrite the bargain and avoid responsibility and the consequence of their bargain.
It's your position that obviously the case shouldn't have been dismissed under the circumstances where the contract, the settlement, the settlement indicated that there was supposed to be payment, and that if there was a failure in that payment, then the entire issue amount would have been accelerated.
Well, the stipulation has a provision for an immediate filing of a stipulation of discontinuance.
That didn't happen.
That
right?
didn't happen. So when my client when there was a violation of the stipulation, my client incorrectly filed a motion. Defendants responded by filing the stipulation of discontinuance, and the court just let the motion go because the case had been discontinued. And by the way, that was not the correct mechanism for seeking.
But then again, the second application was met with dismissal because it wasn't going to not to revisit re-argument.
Correct, and the court even said in that decision that the plaintiff did not avail herself of the correct mechanism for enforcing a violation of the stipulation of settlement. Then I came in, and I'm not patting myself on the back here, but I
wasn't saying that you were, but good
I filed the proper papers under 3215I, and I requested that the clerk sign the judgment. The clerk said, we don't see that a default still exists, which brought up the major issue that is the issue in this case, is that I don't believe that there's a dispute that even in defendant's papers, that there was not strict compliance with this stipulation of settlement. I don't think there's much dispute in the facts. We concede that the two delinquent payments were eventually restored, but they were restored after the 3-day notice to cure. They were late, which in our opinion made them an incurable default. The defendants expressly agreed to the following: to strictly comply with the stipulation, to take all responsibility to cure a default within the cure period, and with notice having been waived, to take all responsibility for setting up automatic payments such that payments would be received. It says that in the stipulation, that they must be received.
So the problem here seems to be that then the defendant indicated to the court that the problem was with the bank. It wasn't their fault. They had set up recurring payments, correct? And apparently something happened to the bank, and the court found on motion 6, which is, I guess, the order that's being appealed here today, that was not a basis for finding that the defendants were in default.
Correct, and we respectfully, vociferously disagree. You know, on the one hand, so even if it were a basis, there's insufficient evidence of a bank error. The only evidence of a bank error is a hearsay statement by the restaurant manager, not a representative of the bank, that something happened. And we don't even have a name of the person, the individual at the bank that they spoke to, so that we could investigate that. And the law
Let
is
me just
clear.
ask you a quick question before
Of
your
course.
time is up. Should the technical failure that you were talking about, what happened, your client didn't know that, should that failure to comply with the requisites of the substitution of counsel under CPLR 321B impede, prevent us from changing the decision or reversing this decision?
So thank you for that question. I don't believe that there was a technical failure on the replacement of counsel. And why is that? Because there was a stipulation of discontinuance before I was retained. The ethical rules, I cited to them in my brief, say that that when a matter is over, representation ends. Number 2, my client has a right to choose counsel. Even if there was a technical failure, there is substantial case law that says that such a technical failure, we haven't heard from other counsel. It's to not impede on a litigation. There's been no impeding on the litigation. Number 3, there was no cross appeal here. So this was not preserved for appeal. And frankly, the court did not rule on that issue.
Well, there doesn't have to be a cross appeal for them to comment on it, but I get your point. Thank you.
Thank you. And thank you, Your Honors.
Yes.
Good afternoon, Your Honors. Robert Chapnick of counsel for the respondents. Your Honors.
Counsel, my Michael, yeah. I just want to start in the stipulation of settlement, paragraph 5.
Yes, Your Honor.
Where it indicates that defendants, in the event defendants fail to timely make any of the weekly payments, they shall have a cure period of 3 business days. Inside that same section, there is no notice from the plaintiff is necessary if missed payment shall be required. And so just in terms of when the payments were made they made within that 3 cure, because we know the payments weren't made. They were not made within that 3-day cure period. So what is really your defense to that?
Well, 2 things, Your Honor. So first, if we look at the provision immediately preceding that, provision 4, it specifically provides that defendants shall set up recurring payments with their bank so that the weekly payments are made and received automatically by plaintiff. It is undisputed that the respondents did that. They set up the payments with the bank. It was the bank's anti-fraud software, not an act or omission by the respondents, that resulted in the lateness of those 2 payments.
Does it say anywhere in here that it has to be an act or omission by the defendants? I mean, it would seem to me that if the defendants have to make this payment within, weekly payments, have a 3-day cure period, and there's no notice provision for which you can hang your hat on, that it's on the defendants to make sure that these payments are made. And if they're not made, then rectify that within 3 days for whatever reason it is. And then go into your adversary's points that there was nothing from the bank that even indicated that there was, in fact, a bank error.
Well, there is an affidavit, as counsel for the appellant noted, there is an affidavit from the bank, from the respondent's manager who had correspondence with the bank.
Isn't that hearsay, though? I mean, didn't we need something more than just, I mean, I appreciate that you put that in, but didn't we need something other than that?
I don't believe so, Your Honor. It wasn't disputed. It wasn't disputed by the appellant, and the appellant could have easily called up the bank themselves and tried to find out what happened.
Why would
Nobody
why
did.
would the appellant do that?
Yeah.
They don't have the duty to make payments to them. That's your duty. Why would they do that?
Well, I'll tell you why, Your Honor, because the appellant waived this alleged breach.
Based on what provision of the contract?
Well, it's
Well,
well
the stipulation.
established, it's well established that any provision of a contract can be waived if the party doesn't seek enforcement, and in particular, provisions of a contract that pertain.
When the payments weren't made, the motion for the default was brought within days of that, quite frankly, like less than a month.
But the payments were accepted, along with every other subsequent payment. So any provision that pertains specifically to timeliness of payments can be waived if those payments are accepted.
Is that what our case law says? That the mere acceptance of partial payments without anything more, it indicates a waiver?
It actually says knowingly accepting, which there's no dispute that the appellant knowingly accepted these payments, and not just the 2 late payments, but every subsequent payment such that the appellant was completely paid. The appellant has been paid everything except for this liquidated damages clause that they're trying to enforce in this case. And I just want to point out, the appellant has had 4 bites at this apple. There was the pro se motion, there was the motion to re-argue, both of which were denied, then the end run procedure to go directly to the clerk to try to get the clerk to sign a judgment, and then the 4th motion, which is the denial of which the subject of this appeal. So this appellant's already had 4 bites at this apple.
Thank you.
Thank you, Your Honors.
Your Honors, I'll be very brief. Just addressing the waiver issue. There was no knowing, intelligent waiver, which is required by the law. These were direct deposit payments. My client did not waive it. As Your Honor correctly observed, she attempted to enforce the stipulation almost immediately. There is no authority cited by counsel here or in his briefs that says that a mere acceptance of payments waives any breach that was not properly cured. So I would reject that out of hand. With regard to liquidated damages, this is not as I said in my brief, this is not a liquidated damages clause. As is often the case when cases settle, there is a heightened damages, which are the true value of the damages in the case. My client sued defendants for a lot of money, including punitive damages, and took a discounted amount. There is nothing in here that's a penalty. These are sophisticated actors who made an arm's length agreement, who frankly should be held to their bargain. If I just may make one more comment, an end run around the motion practice. It was actually the motion practice that was the incorrect procedure. The end run to the clerk was actually the correct procedure under 3215I. And with that, I'll rest on my briefs. Thank you so much, Your Honor.
Thank you. Thank you both. Island Consolidated versus Grassi and Company.
May it please the court, my name is David Wilk. I represent the Grassi defendants.
Counsel, I noticed in your opening brief, you did not address the Lemley case from this court in 2018, which addressed the continuous representation doctrine in these kinds of malpractice cases. And in reply, because it was then raised in the respondent's brief, but in reply, you didn't address it either. I just wanted to know, because it seems to me that the Lemley case is really on all fours with what we have going on here, and I just wanted to know if you wanted to address that.
So you're talking about the continuous representation rule?
Yes.
So in the APR matter versus Deloitte, the court found that in the retainer agreement, if an accountant limits the statute of limitations by retainer, the continuous representation rule that you are able to argue when the common law applies does not apply when you limit it. And it permitted an accounting firm, exactly like Grassi here, to limit the statute of limitations, and it takes out the continuous representation argument. So here, what we have is the parties agreed that we're not going to have the 3-year statute of limitations pursuant to the CPLR, which gives you that benefit of a continuous representation. Here, instead, what we argue is the agreement has 1 year to provide notice to Grassi of a dispute upon the completion of services, not continuous representation, but the completion of services. Here, the services were completed in 2015. How do we know that? Well, the complaint says advice was given in 2015. We structurally changed our company in 2015. However, the agreement that Grassi entered into with the plaintiff says you have 1 year to let us know if there's a dispute, and then you have 90 days to seek mediation.
Right,
and they didn't.
But then when the audit situation came up, did your client not pursue that on behalf of plaintiff?
Well, so if you're talking about the audit in 2021, okay, even if that is the operative date, plaintiff filed a summons with notice in June of 2022. They had a year pursuant to the agreement to do that, and that's still, February 21 is the date that you're talking about with that audit, so June of 22 is over that time frame. It's over a year, and the reason—
But then your position is that even if it was continuous representation because it was limited in terms of what the statute of limitations was?
I'm not saying even it's a continuous representation. What I'm saying is if the retainer agreement applies, what the plaintiffs did here, even if we use the operative date of February 21, instead of seeking mediation, which
And
the
if the
parties
retainer
bargained for—
agreement doesn't apply because the retainer agreement specifically took out issues pertaining to sales tax, what's your position then?
Okay, the retainer agreement does apply, and I'll get to the sales tax issue in a second if you let me do that. But if the audit is in 2021, under the case law, there's a case against Proskauer where the court said that it wasn't anticipated that they would do the audit in 5 years later, and therefore continuous representation didn't apply. However, going back to your issue regarding sales tax, what the plaintiffs have argued is that there is a provision in our agreement that calls for the fact that an enterprise such as Island is supposed to do its own reporting. The plaintiffs basically said that sales tax advice is not in there. I say I have 2 minutes. What they say, sales tax advice is not in there, but that's misleading. What it says is sales tax reporting. It says employment reporting. So in other words, an entity such as Island does its own reporting. There's no allegation that Grassi was hired to do reporting. We're not a bookkeeper. What the argument is that they failed to render proper sales tax advice, not sales tax reporting. Reporting is something that a company does on its own. So therefore, we don't see any reason why the retainer agreement shouldn't apply. And again, I want to just stress—
Does the retainer agreement apply under the additional services
Yes, so the
component?
additional services provision of the retainer agreement is expanding on the scope. So initially, there was nothing in there regarding doing sales tax, right? But the additional services expands on the scope, but it keeps the terms. And in there it says—
There was no agreement. There could have been, but there was no subsequent agreement, right?
And that is correct, but the additional services provision allows for that. It says separate agreement or nothing at all. But my point that I want to make is that the reason why this case should be dismissed is because the parties bargained for mediation to happen before filing of a suit.
Wasn't there
and they
some
didn't do that.
issue with regard to mediation? I said, wasn't there some issue with regard to mediation when the party emailed the defendants offering
yes,
to engage
terrific.
in mediation, I think 2 months
Terrific point.
before they file the complaint.
No, they filed a summons with notice in June of 2022, which in New York is tantamount to initiating proceedings and commencing an action. Then, 5 months later, in November 2022, they sought mediation. But the cat's already out of the bag. They already filed a lawsuit against Grassi, and the whole point of the mediation provision is to do it beforehand, not afterwards, because the bargain was that we're going to try to resolve this amongst ourselves privately.
Well, they filed
They
the
took it upon
summons. It
themselves
wasn't, they had filed the summons. They didn't file the complaint.
They filed a summons with notice, and under CPLR 305B, I believe, that is tantamount to commencing an action. And in the summons, you actually have damages, you have accounting malpractice alleged, and you have the name of Grassi, all public. That's the exact reason why they had the mediation provision. So I know plaintiff argues, well, we didn't file the complaint. That's of no moment. The retainer says that you cannot initiate legal proceedings before mediation. New York allows a summons with notice to be the commencement of an action. It's the initiation of proceedings. And by asking for mediation afterwards defeats the whole purpose of that condition.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court, Mike Rayfield on behalf of the island entities.
Counsel, if you could just address the issue that we started out with in terms of the limiting of the statute of limitations and how that affects your position.
Yeah, so I think it's important to separate out two issues because in response to your questions about the Lemony case, I think it's called, my friend responded that the engagement letters cabin the limitation period. But that depends on the question of whether the engagement letters apply to begin with. First, there's the question of whether the engagement letters apply, and if not, then the second question is whether we complied with the statute.
And your argument is that the additional services provision does not cover the issue at hand, so the retainer agreement does not apply. Is that your argument?
Exactly, and everyone agrees that unless those letters apply to Grassi's sales tax advice, the plaintiffs had no duty to comply with any mediation condition precedent, and there's no limitation on damages.
In the additional services provision, at the end of it, it says, in the absence of any other written communication from us documenting such additional services, our services will continue to be governed by the terms of this engagement letter. Why does that not mean that any other additional services performed for which there's no additional agreement will continue to be covered by that retainer agreement reference?
Because that language is cabined by the phrase absent other written communications. There were other written communications. What that provision says is that an agreement can be made without a letter if other written communications document the service. And there were extensive communications documenting Grassi's sales tax advice. But even, you know, and that's just reading the additional services provision in isolation. Every single engagement letter in the record has a list of covered services. Sales tax advice is not listed in any one of them. And that alone, we think, is borderline dispositive. In the 5-year period after Grassi gave us the sales tax advice, the parties signed 6 separate engagement letters. Grassi had every opportunity to sweep this advice into the letters if it wanted to, but it never even tried. And as the drafter of the engagement letters, any ambiguity has to be construed against Grassi. There's only actually one mention of sales taxes in the letters, and that is in the section that says, our engagement does not include the preparation of various reports, including for sales taxes. In other words, Grassi went out of its way to carve this advice out of the
But isn't there another indication in a letter that they indicate that they would be happy to help with that, right? They would be happy to help with the sales tax issue.
Sure.
And they could do so by engaging in another agreement, a separate engagement letter.
Yes, and they never did make a separate engagement letter. Instead, they agreed over email that documents the services to provide the plaintiffs with the sales tax advice. And those email communications are the other written communications in the additional services provision where you can make an agreement without a letter, and then there is no condition precedent or mediation requirement. Now, as to the statute of limitations,
the written communication that you're referencing, you're talking about emails relating to the sales tax advice only, or are there any written communications that speak to the extent of the services that were going to be provided with regard to the sales tax issue?
Yes, what the additional services provision says is that if there are other written communications documenting the service, then you can make an agreement without providing engagement letters. And so, yes, what we're referring to are email communications, extensive email communications, including one we block quoted in our brief, where the parties are talking about the sales tax advice that's being given. And so long as the communications are clear about what the service is being performed, Grassi can simply perform that service and bill us for it without the need for an entire engagement letter. And again, at minimum, if you think that there's some ambiguity here, it has to be construed against Grassi. I do want to address the statute of limitations, which under this court's precedents, the statute of limitations is told if the defendant continues to represent the plaintiff in connection with a specific matter directly in dispute. That's Ackerman v. Price Waterhouse. Up until 2020, Grassi was consistently telling us that we were exempt from the sales tax, and we were relying on that advice to structure our business. Then, in February 2021, the NYSDT audited us in connection with the sales taxes that we hadn't paid in reliance on Grassi's advice. Grassi represented us in that audit, as Your Honor pointed out, and an appeal until at least October 2021, well within the 3 years that we commenced this suit. So as the Supreme Court explained, Grassi, quote, provided their professional advice and guidance regarding the sales taxes by defending a tax appeal on the exact issues through late 2021. And that makes this case exactly like this court's decision in Lemley v. Reagan, which held that the continuous representation doctrine applied when an accounting firm submitted a response to a state audit defending and explaining the advice that had caused the audit. Grassi simply ignores the sales tax advice, the tax appeal in its briefing. And finally, I just want to mention that what Grassi's position is about the additional services provision in the engagement letters. What their position is that any work it performs is covered by the engagement letter, regardless of whether it's even mentioned, unless that work is addressed by a separate engagement letter or an amendment to one.
But that's not what your agreement says.
That's not what the agreement says. First, it would completely defeat the purpose of having a carefully delineated list of covered services. It would effectively read that list out of the engagement letters. And second, the additional services paragraph simply doesn't say that a letter is the default. It says that the agreement can be made without a letter if other written communications document the service. And again, there were extensive communications documenting the service.
Yes.
Thank you.
Thank you.
Thank you. I believe that counsel just made our point and solidified the additional services argument because
Well, counsel, with regard to the additional services argument, in the absence of any other written communication from us, does that relate to the sentence right above it where it starts to talk about separate engagement letter? Does the other written communication apply to the phrase of separate engagement?
No, so what it says is we could have a separate engagement letter or additional communications or nothing at all. But what counsel, what he's ultimately stated here is that there were communications discussing sales tax, which is exactly what was contemplated here. So they expanded the scope by additional communications, and there's no other documents in here that talk about other terms. So the terms of the engagement, which from 2009 all the way to through 2021 existed. So with the fluidity of a representation, Grassi is helping out on a sales tax issue. There are communications which now verify that they're doing sales tax, which is contemplated by documents, documentation. And then if there's no other specific different terms, the terms will continue because that additional services.
But if you had other engagement letters after that, why not put in the sales tax engagement?
Because I think the idea is that it's a catch-all, and as an accounting firm, they might be asked and called upon to do a variety of different things, which is why they have the additional services in there, so they can be flexible and expand the scope, but still make sure the terms apply.
They never even mention in their additional services that is one of them. I mean, it's not like this was 2015 and it ended in 2016. It went straight through till 2020, and then they came back to represent them in 2021? Is that right?
So the services, it's clear that the complaint talks about services rendered in 2015, they immediately took action. Then in 2020, they have this memo,
audit.
right, that memo. If you're asking why not address why not fix the retainer, because the retainer as is catches that what exactly occurred here, the retainer covers.
Thank you.
Thank you so much.
Thank you both. HG versus NYC Transit Authority.
Good afternoon, Your Honors. Scott Seskin, Seskin and Seskin, appearing on behalf of the appellants. May it please the court, in this matter, there are two significant questions, the first of which is whether or not a party is going to be required any longer to comply with a statutory requirement in order to bring a motion for summary judgment on. In this matter, the respondents failed to include a copy of the pleadings. The pleadings were never referred to in either the moving papers, and they had an opportunity in the reply papers as well to go ahead and reference the pleadings, to reference them in NICEF, to append them.
Did you argue that in your brief?
Yes. Yeah, it's throughout the brief. The defendants, the respondents failed to include the pleadings. And before the lower court and during oral argument, that issue was raised. And it caused the lower court to stop any argument without soliciting anything on behalf of the plaintiffs as to the substance or merits of the matter. And the court summarily said that the defendants had to include them, that they also failed to meet their prima facie burden. And that was the end of argument. That obviously changed in the court's decision. The court decided to ignore that statutory requirement, but that really should have been the end, and we really shouldn't be here having to even reach the merits of the defendant's motion. The second issue is whether or not a party is going to be required any further to meet its burden of proof on a motion for summary judgment, regardless of the sufficiency of the opposing papers. In this matter, the record is very clear, and the decision is very clear by the judge, that it was the defendant's papers that were used, the defendant's exhibits, the supporting documentation, to support the move-ants motion for summary judgment, which was only supported by a few pages of testimony. There were about 10 pages of testimony from a bus operator, a few pages of testimony from one of the four plaintiffs, and about 1 or 2 pages from another infant plaintiff. The court, in making its decision, specifically stated that the plaintiff's papers would be used to support the defendant's burden of proof, and the lower court cited 2 lower court decisions from, I believe it was either Kings or Queens County, one of which actually supported the plaintiff. But there was no precedent that should be followed, nothing from this department, nothing from the second department, from the appellate division, or from the appellate division first department on that. The next issue, which the court completely ignored and made a finding of fact, had to do with the issue of the false imprisonment of the 4 infants. The lower court looked to the fact that the infants, after the assault occurred, that they were then able to later on exit the bus to make its, or find and conclude that point that the children, the infants, were free to leave, and therefore they were not falsely imprisoned. But the court never looked to the time in which the infants were actually being assaulted as to whether or not they were free to leave and the circumstance.
The person who was making them not free to leave were the assailants, not this particular, the city defendants.
That's correct. However, it was the bus operator who allowed the assailants to enter the bus.
I don't
and
think
allowed,
so.
Excuse me?
I don't think so. The door was opened by the persons who were in the car, in the bus, who were working with the people who were outside of the bus, who they called.
Well,
they opened the door.
Well, let me just say one thing about that point. That is correct. That was not in the moving papers. There was no testimony to support that argument in the moving papers. Having said that, the bus operator, based on the case law from the Court of Appeals in this department, had an obligation to go to the back of the bus, to go ahead and collect the fares from the 10 thugs that got on the bus.
But that's not the false imprisonment claim.
Well, that is part of the false imprisonment because there is case law which speaks to what false imprisonment or intent to imprison somebody consists of. And it's the evidence of the defendant's actions, omissions, and the plaintiff's state of mind which will satisfy the element of intent.
You're saying that the bus operator should have left the cubicle that they were in and gone to the back to collect fares. You have some case law that says that? That's
I'm
what
sorry,
the
Judge,
obligation
I didn't
of
understand the question. I apologize.
I'm sorry, but I thought you said that the bus operator was supposed to go to the back of the bus and collect the fares
Yes.
from the people who came on.
That's correct.
Do you have some case law that supports that bus operators have to leave the wheel, when I think they've pulled off. She was at a stop, they came on, she continued off. The fight didn't happen right away, it happened soon thereafter. Was she supposed to stop the bus in transit to go and collect the fees? What case do you have that supports that?
Well, Judge, the bus wasn't in transit when it happened. The bus operator.
They came on, obviously, when the bus was stopped,
Right.
but it didn't immediately begin. She started to drive off, and obviously the altercation ensued.
I can't speak to exactly when the altercation
Well, that's
began,
a good point. If you
but-
can't speak to that, I don't know how you can say that the bus operator was supposed to be collecting fees, nor do I know what case you're relying on.
Judge,
In any case, you have some rebuttal, so why don't you get to that point and your rebuttal, okay?
But there are...
On your rebuttal, okay?
I'm sorry, Judge?
You have rebuttal time, so why don't you get to that point on your rebuttal? Thanks.
And the last point...
No, rebuttal is, I'm asking
want
you
me
to
to wait?
sit down and then finish up on your rebuttal.
Thank you, Judge.
Okay, thanks.
Good afternoon, Your Honors. Teresa Frame from the MTA Law Department on behalf of defendants' respondents, Transit. I'd like to first just point out that plaintiff's argument that Transit failed to submit the pleadings must be disregarded as it was only raised in the reply brief to this court. Transit did not have an opportunity to address that in its respondent's brief, so it must be disregarded. I'd like to just really address the heart of these claims, and that is plaintiff's theory of liability is that the bus operator should have prevented this assault in some way, shape, or form. And in the first two causes of actions at issue in this appeal, the fourth and fifth ones, the bus operator should have prevented the assailants from boarding the bus, or should have gone back to see if the assailants would pay the fare. In that regard, the law is well established that Transit can only be held liable for failing to prevent an assault if there is a special relationship between plaintiff and Transit.
Do we have to get to that? You made the motion, right?
Yes, Your Honor.
And so you should have made a prima facie case when you, with your papers, when you made the motion.
Yes, Your Honor.
And if your papers are not in proper form, if they're deficient, if you don't make your prima facie, then that's it. It stops. End of story. We don't have to get into the facts. That's the argument that they're making. So did you make your prima facie case when you made your motion?
Yes, Your Honor. As I set forth in my brief, our factual showing was excerpts of transcripts. There is nothing inherently wrong with submitting an excerpt of a transcript, as long as it's not misleading.
Did you submit a copy of the pleadings?
No, Your Honor. However, that is a procedural defect that can be overlooked by the court where there's no prejudice to the parties. And here, neither party can argue that there wasn't any prejudice. Indeed, The court did consider the pleadings by addressing them in the motion for summary judgment. They talked about the allegations therein. It was well considered. It's not as if the pleadings would have illuminated this motion practice anymore. Because transit made its fine, if I could return just to the substance of the causes of action, it's undisputed that no special relationship existed between plaintiffs and transit, which is the undisputed requirement for transit to be held liable for failure to prevent an assault. Instead, the plaintiffs are arguing that transit may be held liable in absence of a special relationship. There is one limited exception that plaintiffs rely on, and that is that transit may be held liable for failing to summon aid where its agent watches an assault occur from a vantage point that offers both safety and the means to summon help without danger. However, that limited exception does not encompass the failure to prevent an unforeseeable criminal assault. These actions that are at issue in the fourth and fifth causes of action is the bus operator failed to prevent the assault. It failed to prevent these assailants from boarding the bus, failed to collect the fare in a way that the assailants might say, oh, I don't want to pay, or I don't want to assault someone because the bus operator's back here and I feel threatened.
So you're saying there's no special duty as to that, but you're not arguing that the bus driver didn't have an obligation to alert police, for
That's
example?
correct, Your Honor, and that's a limited exception that I was addressing. The fourth and fifth causes of action.
But that's not, there are other additional causes of action that were not dismissed here, correct?
Certainly, Your Honor, there are many causes of action that remain active.
What about, can you address the false imprisonment as you see it?
Absolutely.
Cause of action.
As plaintiffs have admitted, the confinement that occurred during the assault, which is the theory of liability that was articulated, was perpetrated by the assailants, not by the bus operator. So the bus operator cannot, and transit therefore cannot be held liable for false imprisonment.
I mean, counsel said something about you can infer the intent because she didn't go back and do anything as to false imprisonment.
I believe that's a sort of a theory of failure to prevent false imprisonment by the assailants, and again, that would go back to the fact that there was neither a special relationship, nor does that fit within the limited exception of failure to summon aid. Unless there are any questions, thank you.
Your Honors, counsel just stated that the first time that the issue with regard to the absence of the pleadings was raised was in reply papers to this court, but actually I'm looking at the brief in case, the first, in chief, excuse me, and I mentioned it right on the first page, right under the argument. I mentioned, as previously noted, the pleadings were neither attached nor referenced, and I also mentioned bills of particulars.
That's your brief to us.
And it's also before the lower court as well.
But did you put in, are you reading from the brief before us or the brief before the lower?
No, I don't have the lower court papers with me.
okay.
But they were referenced in the lower court papers, and the respondent had an opportunity, obviously, at that time to put them in. I expected them to come in the reply papers, but they didn't. And although counsel now argues that the failure to include the pleadings can be overlooked, I'm unaware of any case law or anything which would state that a statute can be overlooked. The CP Law 3212 is very clear and states that a motion for summary judgment shall, using the word shall, not may, not might, not could, but shall be accompanied by a copy of the pleadings. And
Did you
that
put the
wasn't done.
pleadings in your opposition to her motion?
I did not, for that specific reason, to go ahead and not be held to have supported the defendant's moving papers. Nonetheless, the court did find that. The court has already discussed the issue with regard to the failure of the bus operator to take any action, and that's what I was alluding to before, Your Honors. That had to do with the Crossland cases where, regardless of the absence of a special relationship, if someone from the MTA or a municipal corporation witnesses something that's happening, they have an obligation to take some kind of action, or at the very least it creates a question of fact for a jury that shouldn't be decided or can't be decided by the lower court.
Thank you very much.
Thank you.
Thank you both.